past.
The request
Obliged.
by the land council petitioner. Matter is adjourned. Let the matter be listed.
May I please, Your Lordship? I beg to mention for listing one civil revision petition for motion lodge. Tomorrow, day after tomorrow, 22nd January. Motion matter,
Day after tomorrow. Civil revision.
civil revision. Deeply obliged.
My similar prayer, my civil revision petition. I am paying for lifting, my admission matter, my any day,
Or?
my next week.
Admission.
Yes, ma'am. Next week, ma'am.
Next week. Any date you want.
Yes,
Next week
ma'am.
better date.
Hmm.
27th.
My lord, I beg to mention one second appeal, RSA, regular second appeal, to come up for hearing, my lord, on Thursday, my lord, 27 January.
Why it has not come up for hearing since
Early, it is the year 10, my lord, number 2, RSA 280/2010. Last year it was come for hearing, my lord. Thereafter
2010.
10, my lord.
10 matters.
Yes, my lord.
So you have to make a mention before there was just as concerned. Yes, any listing date? You want any Thursday?
Thursday, yes, my lord.
29th.
29th.
29th is a Thursday. I think.
Yes, my lord. My lord, another prayer, FAO, my lord, to come up for order, my lord. IA, civil, my lord, for condonation of delay, my lord. It is on Friday, my lord, coming Friday.
Oh, sorry, Friday is a holiday. Maybe on
Thursday.
Thursday.
Thursday, masobla.
May I please, Your Lordship, I beg to mention for a listing of transfer petition on
Why it is so urgent, transportation?
because the little children are also involved in this matter, Your Lordship. May come up on the next week, Lordship, on 28th of January.
20th of January.
May it please your lordship, I beg to mention 2 IA, one for substitution and one was supposed to be listed in December, your lordship. It has not been listed yet in the orders called.
2 I miss one for substitution and another?
It was supposed to be listed in December. It has not been listed yet, so I plead that it should be listed day after tomorrow.
No, 2 I's means one for substitution and another for?
For urgency, your
No, you have submitted 2 I's are there. One for substitution and another, what was the another?
151 CP.
One for?
Section 151 CPC.
Any prayer was there? 28.
May it please, Your Lordship. Lordship, I beg to mention for listing of an CRPIO. There is a stay operating against us. Matter may come up the day after tomorrow.
Day after tomorrow may not be possible. Let's
Perhaps
be on 27th.
27th. Obliged. My lords, I have also a prayer for adjournment on item number 8 on behalf of Mr. Darakulla.
Item number 8.
My lord.
Yes, on behalf of
Mr. Darakulla.
Darakula is for the respondent.
Respondent. We were supposed to file a...
Have you informed the other side for the applicant?
Yes, my lord. We have consent.
You have informed?
Yes.
With the consent of the other side. The learned counsel appearing on behalf of Mr. Darakula, counsel for the respondent, paid for an adjournment. Placed the matter after 1 week will do. After 1 week as on a date.
Lord, item number 18 to 20 listed for hearing were for the applicant and the petitioner. But if I may pray for adjourning the matter for 4 weeks.
On FA is also there, CRP is also
Yes.
there. So you are for the?
I am for the applicant and the petitioner in the civil revision petition and applicant in the FAO.
And in civil revision petition, you are for the
Petitioner.
petition.
Yes.
18, 19, 20. Have you taken consent?
Yes. Yes.
তিনটা এক লাগে করিডোর with the consent of the others. This was the learned counsel appearing for the petitioner in CRP IO so and so and FAO for the appellant and respondent for number 20. No, yeah. Considering the submission made by counsel for the petitioner appellant, matters are adjourned. It will be listed after 2 weeks.
For 4 weeks if possible.
After 4 weeks. Let the matter be listed after 4 weeks as an edit to be released.
Much of it.
Please, Your Lordship. Your Lordship, I beg to mention listing of few MFAs, Your Lordship.
Huh? Few?
Listing of few MFAs. MFA.
MFA, few.
Ma'am,
How many?
3.
3.
Ma'am,
For?
please,
For?
Ma'am?
In what stage it is? Admission?
hearing, Your Lordship.
Hearing stage?
Then these MFAs were supposed to be listed on 28/10/2025. Same was not listed, Your Lordship.
তিনটা আছে হিয়ারিং ওখানে একটা হিয়ারিং অ্যানিমেন্ট তো পসিবল না possible may not be possible for 3 matters to be listed for hearing because other matters are already been listed, so you may
Your Lordship, if possible,
okay, it may not be possible, but still we are listing it on 29. Let us see. 29th. Because
Your
3
Lordship,
MFA for hearing
Ma'am, Your Lordship,
difficult.
if possible, may be listed on 20th February
28,
2020,
20 February Kiva. Is a
Fri-
hearing
Fri-
day?
Friday.
Friday not possible.
Ma'am, Your Lordship,
Friday is not possible. 19 will do. 19 February.
yes, sir.
19.
May please, Your Lordship, I beg to mention for listing in the MFA, my lord, is a 2010 matter, my lord. And the respondent, my lord, the claimant.
In what stage it is hearing?
It is not hearing, my lord. The matter was dismissed for non-prosecution. The insurance company was not appeared. They have filed an I for register. Matter was registered, my lord. Then after it was not listed. Next week, my lord, any day.
Three zero.
30,
30 of this month will do.
30, my lord.
30th of January. 30.
30, my lord. 29, my lord. Then 30, my lord.
You have another.
29, 29.
Okay, good.
May I please, Your Lordship, I beg to mention item number 15. Senior Counsel Mr. PJ Sweke has some difficulty today. Kindly matter fixed on the month of March.
Here the matter is respondent is not appearing here, na? Respondent side is not appearing here.
Yes,
Your good name?
R.K. Mohanto.
Heard Mr. R.K. Mahanta appearing on behalf of Mr. P.J. Second, the learned senior, praying for an adjournment due to personal inconvenience on the part of Mr. Second. Prayer allot. It's the matter in the month of first week of March.
Lordship, kindly date may be given.
First week of March. Yes. 10th of March.
Obliged.
May I please, my lord. My lord, I pay for listing of an IA, my lord. I have filed for withdrawal of the money deposited by the appellant, ma'am. Next week, any date, ma'am. Orders,
28.
28. Obliged.
May it please, Your Lordship. Lordship, I would beg to mention a matter for hearing.
What kind of matter?
Workman compensation, Your Lordship.
I think the next 2 weeks full of actually.
Any date in the month of February, if possible. Nineteenth,
17th.
much of it.
You have received here the scan copy, na?
Yes.
Scan copy. The last occasion, most surely some witnesses, statement of witnesses we required to call for. I don't know whether it has come.
It has come, Lordship.
Yes.
Yes, Lord. Your Lordship, the fire is at page number
Page number.
11, Your Lordship.
Yes.
May I read, Your Lordship? Here, under the secret information by the police, two individuals were arrested. One is Abdul Kayam and the other one is Tinku Ali. And based on their information, the police, they went to the place called Chingya Suk, where they have seized one vehicle, AS04E6117, Tata Indica, from where 11 carton of cough syrups were, banned cough syrups were seized, Your Lordship. And that is from the premise, as per the information, from the premise of the accused petitioner, Your Lordship. And from two more places also, they have recovered the cough syrup. Now, Your Lordship, the petitioner, he approached the Honorable Court by filing a anticipatory bail, in which Your Lordship has directed to surrender before the trial court. And accordingly, the petitioner, he surrendered on 19/4/2024. And since then, he was in
Standard of 19.
19/4/2024, or 25, Your Lordship. Now, in between, since today, I think 3 seizure witnesses were examined, Your Lordship. Already, I have enclosed 2 witnesses at page number 50 and 52. Page number 50, PW1, Your Lordship. It is Noyan Jyoti Kolita. He is a seizure witness, Your Lordship. And as per his statement, Your Lordship, nothing has been revealed against the petitioner, Your Lordship. May I read the seizure, Your Lordship? Oh, note, I am not acquainted with the informant, SI Jaswantanath of this case. I am acquainted with the accused person, namely Abdul Kayam, Tinku Ali, Pulok Jyoti Kolita, Ajay Bora, and Lasit Bora. They are my fellow villagers. The occurrence took place about 5 years ago on a particular day during the night at our village, Tiniali. At the time of occurrence, after having dinner, I was strolling on the road in front of our village. Then 3-4 police personnel approached me and instructed me to sign a document. Accordingly, I complied. Exhibit P1 by PW1 is the seizure list, and Exhibit P1 by PW1 is my signature thereon. And here, in cross-examination by defense, he said that the police took my signature on a blank paper, Your Lordship. Before obtaining my signature, the police did not serve any notice upon me. The police did not show me any seized article, Your Lordship. And PW2, Your Lordship, page number 51. Here also, same thing has been stated by PW2, Your Lordship. But here, PW2 has been declared as hostile, and in his cross-examination, that is in page number 52, Your Lordship, by prosecution, it is not a fact that I stated before the police that on 26/7/18, at about 8 p.m., one police vehicle asked me to halt near the road, and as per the direction of the boys accompanying the police team surrounded the house of Lasit Bora and Pulok Jyoti Kolita. That they recovered and seized 16 carton of cup care tea from the backside of the house of Lasit Bora, containing 16 bottles of cup care, each of 100 ml. They that they recovered and seized one carton containing 100 bottles of 100 ml cough care from the motorcycle belonging to Rashid Bora, bearing registration number so and so, and that I signed the said seizure list. It is not a fact that I stated before the police that upon searching the house of Pulak Jyoti Kolita, the police recovered and seized 11 carton of Arbrex cough syrup containing 120 bottles from the car park in the courtyard of his house, bearing registration number so and so, and that accordingly I signed the seizure list. So thereafter, again by cross-examination by defense, before obtaining my signature on the seizure list, the police did not serve any notice upon me. I did not make any statement to the police, although the police wrote a statement on my behalf. The said statement did not belong to me. The police obtained my signature on a blank page. The police did not seize any article in my presence. So here, the vehicle which was seized from the premise of Pulak Jyoti Kolita, that is the petitioner, that vehicle doesn't belong to the petitioner also. It was not in his name. And another two witnesses were also, I think one more witnesses were examined, but I have not enclosed here. He also revealed the same thing, Your Lordship. Not against, and nothing against the petitioner. And section 37 also, the petitioner come within the parameter of section 37, Lordship, because prima facie there is no material against the petitioner. So that is my humble submission that he may be released on bail, Your Lordship. And one more prayer, Your Lordship. The mother of the accused petitioner she is very ill, Your Lordship. She's an aged mother. So considering that fact also, bail may be granted.
Lordship, he has not made any submission with regard to section 37. Lordship is well aware that only 3 witnesses have been examined so far, Lordship. And there is a Supreme Court judgment also, Lordship, that based on the only one evidence of the police official, conviction can be given, Lordship, provided it is reliable. That is, Lordship, Colonel Singh. I do not have the copy of the judgment. So now, Lordship, here already 9 PWs are there, 3 have been examined so far. And he is behind the bars for, to my calculation, Lordship, if I am not wrong, 281 days. So, Lordship, it is not a case of prolonged incarceration, because the evidences are going up full phase, Lordship. And section 37, Lordship, has to be mandatorily followed, Lordship. Lordship is well aware. Lordship is
But the question is that he is saying, he is pressing on the question that 3 PWs most probably
Yes.
they have already said it.
Yes,
There's not, there's no such incriminating evidence against him.
yes,
That much his
Yes,
submission.
yes.
So in that context, 37, do you want to submit anything?
yes.
Is there any other?
Even then,
Metric.
Lordship, section 37 has to be followed, Lordship, because 37 is clear, Lordship. Lordship has to have the satisfaction that he is not involved in any other offense, or Lordship, that from the records it is clear that the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any such offense. Now, Lordship, here
But
there
do
are
you think that the submission made by the learned counsel for the applicant that there is no incriminating materials in the evidences of the PWs,
no.
this can be considered as a reasonable ground for
No, it
granting.
cannot be, Lordship, because out of the 9 witnesses, 3 have been examined. The other witnesses, including the IO, based on his admission, evidence, Lordship, conviction can be given. And he is yet to be examined. And I have gone to the 161 also, Lordship, he has clearly implicated the present petition. That is why, Lordship, I had submitted that judgment. I do not have the copy of the judgment, but
Colonel Singh,
Colonel, yes, based on one official witness, also conviction can be given. So thereby meaning, Lordship, that even if the independent witness do not support the case, based on the official witness, also conviction can be given. So that is the gist of my submission. And one more judgment I had come across, Lordship. Again, I do not have the copy. That is of a Ravin Kumar, Lordship, in criminal appeal 2187 of 11. The full bench held that lack of
221.
criminal appeal number 2187 of 2011. Ravin Kumar, RAVEEN, Ravin Kumar versus State of Himachal Pradesh. There, Lordship, the full bench has stated that lack of independent witness doesn't mean, Lordship, that he is acquitted, Lordship. It is based on other official witnesses also, Lordship. So that section 37, he has to mandatorily satisfy Lordship, and Lordship will have to give a recording to that effect also, Lordship. So in my respectful submission, Lordship, there are altogether 9 witnesses, 6 are yet to be examined, Lordship. So at this stage, it cannot be considered. Bail cannot be granted under section 37. And it is also not the case of him that he has been behind bars for a long time, Lordship. That is also not the case. In that regard, also, I had got a judgment, but I will not trouble your Lordship. Even after 2 years, bail was not granted, Lordship. If Lordship wants, I can give that copy. Your Lordship, first of all, Lordship will kindly take up paragraph 8. And this speaks of, Lordship, the global public health crisis that is going on because of the NDPS matter. I will not trouble your Lordship with that. Paragraph 9 also, Lordship will kindly see. It is regarding the concerning increase in drug abuse in India. That also I will not trouble your Lordship. Paragraph 11, Lordship will kindly see. It is paragraph.
Yes, yes, you can read if you want.
Yes, paragraph 11, Lordship. In the present case, this court finds that though the respondent accused was in custody for 1 year, 4 months, and charges have not been framed, Lordship has said, charges have not been framed. Yet the allegations are serious inasmuch as not only is the recovery much in excess of the commercial quantity, but the respondent accused allegedly got the cavities ingeniously fabricated below the trailer to conceal the contraband. Prima facie, this court is to give the opinion that respondent accused is involved in drug trafficking in an organized manner. Consequently, no case for dispensing with mandatory requirement of section 37 is made out in the present matter. Moreover, this court is of the view that as the accused has been charged with offence punishable with 10 to 20 years rigorous imprisonment, it cannot be said that the respondent has been incarcerated for an unreasonably long time. Further, that is my submission. Lordship, it is not that it is not his case also, Lordship. So 37 has to be mandatorily satisfied. And based on only 3 witnesses, that satisfaction cannot be taken by a Lord. In my respect, Lordship.
In the judgment, Your Lordship, the charges were not framed against the accused person. So in my case, charges were framed, trial is going on. And so far, petitioner antecedent is concerned, there is nothing against the petitioner, Your Lordship. And so far, if Your Lordship may kindly see the CS also, charge sheet also, nowhere in the charge sheet, police said that the premises of that is the from inside the house, not something has been recovered. There's nothing, Your Lordship. It is from the vehicle, and nothing has been there in the charge sheet that they have searched the house of the accused and some incriminating materials were recovered from his house. There's nothing, Your Lordship. And so far, satisfaction of the Honorable Court is concerned that he will not do such similar kind of offense in future if bail is granted to him, Your Lordship. And he will comply with whatever conditions were imposed by this Honorable Court.
Pardon, Mr. Judge G. Sharma.
Mr. S. Deka. S. Deka.
S. Pardon, Mr. S. Deka, Learned Counsel. And also pardon, Mr. G. Sharma, Learned Additional application, connection with scan copy of the case diary. This report has already been received. Submitted by Mr. Deka, the then counsel for the petition that if he is innocent and has not committed any such offense as alleged against him. The further submitted that there is an only allegation brought against the present petitioner is that the the vehicle was recovered from his premises, where from the alleged pen cough syrup of the contraband were recovered by the police person. He further submitted that the present accused petitioner earlier paid for this anticipatory bail, but as per direction of this court, he surrendered before the Learned Trial Court below on 19/4/2025, and since then he is in custody. The charge has already been framed, and 3 seizure witnesses have already been examined by the prosecution. Mr. Decker further submitted from the that 2 evidences of 2 PWs have already annexed along with the petition, who are the seizure witnesses, comma. It is seen that so were the seizure witnesses, but most of both the seizure witnesses has not made any incriminating evidence against the present petitioner. Rather, the petitioner PW2 was declared as hostile, and both the seizure witnesses were signed on the seizure list. Signed on a blank paper without and they were not shown the seized articles. Further, Mr. Decker further submitted that petitioner has no criminal antecedent, and he not criminal antecedent, and he is ready to abide by all terms and conditions if he is allowed to go on bail. He being the permanent resident of the address locality, there is no chance of absconding if he is arrested. Mr. Decker further submitted that the murder of the present petitioner is also in bedridden condition, and there is none to look after her. Next one, Mr. Sharma, the learned additional PP submitted in this report that out of 9 PWs, only 3 examined till date. Only 3 seizure witnesses have examined till date, and the other vital witnesses, the official witnesses, as well as the IO are yet to be examined by the prosecution. He further submitted that the accused petitioner is in custody for 281 days, and hence it also cannot be stated to be prolonged incarceration to consider the bail application of the present petition. Mr. Sharma further submitted that there are sufficient implementing materials against the present petitioner in the 161 statements recorded by the investigating officer. In that context, he also relied on the decision of Honorable Supreme Court passed in case of Colonel Singh, citation to DPF. Wherein also it has been held by the Honorable Supreme Court that on the basis of the official witnesses also the conviction can be given to an conviction can be passed. Order of conviction can be passed. In that context, he also relied on another decision of I don't know. Next one. He further submitted that as the cases of commercial in nature, there has to be satisfaction to the court, and then the rigor of section 37 will follow, wherein there has to be satisfaction of this court, and that the accused has not committed such offense, and or there may not be there is no possibility of committing similar kind of offense if the accused is released. But here in the instant case, from the statement made in made under Section 161 CRPC, it is seen that there is sufficient incriminating materials against the present petition, and thus there cannot be any reasonable ground to believe that the accused is innocent. Next, Mr. Sharma also relied on another decision of Supreme Court passed in criminal appeal, in a criminal appeal arising out of SLP packet of criminal 9792 of 2025, wherein also in para 11 of the said judgment, it has been expressed view by the Honorable Supreme Court that considering the seriousness of allegation, the 1 year, 4 months of incarceration cannot be considered to be ground for allowing the petitioner. Next para 11, 12 and 13 of the said judgment read as Mr. Sharma accordingly raised vehement objection and submitted it cannot be a case for allowing the petitioner go on bail at this stage. Next part of poetry. 9 need to say something. Baकी नहीं कह सकते. Order बाकी. Or pass the order. Your submission I have recorded.
Oblige, Your Lordship.
Easy. Have received here this year?
Yes.
Yes, Mr.
Yes, subsequent bail application, Lordship. Earlier, Your Lordship was rejected that order at start phase 27, Lordship.
27.
Yes. In the earlier bail application, the conducting counsel has taken a play of section 47 and 48 of BNSS. Lordship, that was held by this honorable that was complied. Lordship, in this present application, Lordship, I have taken another ground that section 36 of BNSS is not complied with. Lordship, before I start my argument, kindly I would like to read the section 37 of BNSS.
BNS. You want a book?
Alright.
Yes. You're reading on 36.
Yes, Lordship. Procedure of arrest and duties of officer making arrest. Every police officer while making an arrest shall bear an accurate, visible and clear identification of his name, which will facilitate easy identification. B. Prepare a memorandum of arrest which shall be attested at least one witness who is member of the family of the person arrested or a respectable person of the locality where the arrest is made. Basically, this point, Lordship. In the arrest memo, I will show that there is no signature of any attesting witness nor any local person or the respectable person. This is my first argument, Lordship. And then, Lordship, kindly come to section 62 of the BNSS.
Section
62.
60.
Your Lordship got it. Arrest to be made is strictly according to Sanhita. No arrest shall be made except in accordance with the provisions of this Sanhita or any other law for timing in force providing arrest. Lordship, law is clear that arrest should be made as per this Samhita. What the requirement of arrest prescribed by this Samhita, that is BNSS. Law is clear, Lordship. And Lordship, I would like to refer one judgment.
No,
to-
why you are saying that it's not complied with?
Yes, Lordship, kindly, yes, I would like to first show page 36 onwards, Lordship, the arrest memo, page 36. Okay, this is the arrest memo in respect of petition number 1. There is no signature of any attesting witness.
That is, you have already submitted, it is 36 BNS.
Yes.
I'm on 62.
62, yes, Lordship, 62, that is why conjoined reading, Lordship. 36 is the procedure prescribed how the arrest memo should be prepared. And 62 is the Lordship,
That means you
statutory.
are saying that 62 is not compliant, 30, as is 36 is not followed.
Yes, exactly. And Lordship, I would like to refer one judgment, though I have annexed two judgment, one recent judgment of this Honorable High Court of the Ordinance Bench. Actually, I am emboldened by this judgment.
Sit down. Yes.
Lordship, paragraph 5 is the submission of the petitioner advocate, Lordship, purely on 36, paragraph 5, and paragraph 6 is the DK basis, Lordship. Paragraph 7, relevant, Lordship, from para 8. I would like to read, Lordship. The fundamental rights are paramount under the Constitution of India. Article 21 provides that no person shall be deprived of his life and or personal liberty except according to procedure established by law. Personal liberty thus is a sacred and cherished right under the Constitution. Article 22 of the Constitution of India further strengthens the protection of personal liberty of a person by providing that the person arrested must be informed of the grounds of his arrest at the earliest and should not be detained without informing him of such grounds. Next page, Lordship. It is not in dispute that in the case of NDPS Act also, the provisions of arrest of a person as laid down in the BNSS 2023 have to be complied with. In this connection, section 36 and section 62 of BNSS being relevant and quoted herein below. As I have already read it. Paragraph 11, a conjoined reading of the aforesaid two sections makes it clear that a memorandum of arrest is a written document that serves a confirmation that the individual in question was arrested. In addition to meeting the essential requirements, it must provide particulars that are specific. A minimum of one witness is required to vouch for its authenticity. For the best possible outcome, this witness ought to be a member of the accused person's family, or in the event that a family member is unavailable, a respectable individual of the locality in which the arrest is made may be called upon to testify as witness. In the second step, of course, the arrested person is required to countersign the arrest memo himself. What is discernible from the aforesaid two section is that there is mandate provided by the aforesaid section of 36 that arrest memo has to be signed by a witness. Either he is a member of the family of the arrested person or a respectable member where the arrest is made. Section 62 provides that no arrest shall be made except in accordance with the provision of BNSS or any other law for timing in force providing for arrest. Therefore, any arrest has to be made in mandatorily has to be complied with the provisions and procedure of arrest while making such arrest. Non-compliance of such provisions will be in violation of mandatory provisions, which will in turn make such arrest illegal. Once an arrest becomes illegal, the arrested person shall have an unfettered right to be set at liberty, that is to be released on bail. So, Lordship, thereafter, the bail was considered. That is the proposition, Lordship. This coordinate bench of this honorable Lordship. And really appreciate law, Lordship, the interpretation. That is my humble.
Yes.
This section 36 Lordship has come from Lordship the DK Basu guidelines. Case of DK Basu. Lordship.
Ticket.
Yes. If I may just read one or two paragraphs of DK Basu. Lordship. That is Lordship 97 1 SCC 416. Here Lordship
Yes.
the guidelines Lordship it appears at paragraph 35. The same guidelines Lordship, I will not read the same Lordship. Just after paragraph 35 Lordship, I am placing reliance on paragraph 36. There Lordship, I will just read Lordship slowly. Failure to comply with the requirements herein above mentioned shall apart from rendering the official concerned liable for departmental action, also render him liable to be punished for contempt of court, and the proceedings for contempt of court may be instituted in any high court of the country having territorial jurisdiction over the matter. So, Lordship, this DK Basu case, in my respectful submission, came at a time, Lordship, when there was custodial killing, torture was inflicted upon the prisoners, Lordship, or the under trials, and thereafter to check that, Lordship, the guidelines were issued as to the arrest and all that. And those guidelines were interpreted in the CRPC as section 36, requiring the witness attested to be attested by one witness, Lordship. That appears as section 36. Now DNS. Earlier it was 41B. And Lordship, in this DK Basu case, Lordship, it dealt with, Lordship, whether compensation can be awarded to such under trials who have been subjected to police torture, and that was the ratio, Lordship. It has been followed by recent other judgment as well, Lordship. So, Lordship, there is not a single case, Lordship, which says that section 36, if there is a violation of section 36B requiring the one witness, Lordship, that bail has to be given automatically. Now, the important thing is, Lordship, DK Basu came at a time when the NDPS case was not in existence. It was prior to NDPS Act, Lordship. And Lordship, if Lordship kindly takes up the BNSS section 5. Section 5 of BNSS now, Lordship. Section 5, Lordship, saving. Nothing contained in this Sanhita shall, in the absence of specific provision to the contrary, affect any special or local law for the time being in force, or any special jurisdiction or power conferred, or any special form of procedure prescribed by any other law for the time being in force. Lordship, therefore, this CRPC or the BNSS now, Lordship, it is a general piece of legislation, whereas the NDPS, Lordship, is a special legislation. And Lordship is well aware, Lordship, this special, if there is a conflict between both the provisions, Lordship, the NDPS Act will always prevail, because that is a special form of legislation. In that view, Lordship, I am placing this judgment. This is, Lordship, of the Division Bench of Calcutta High Court. Here, Lordship, will see the second page.
Citation
Second page is mentioned in here.
Lordship, in that case already considered. Now I have submitted the judgment. The submission already considered. I think.
Yes, Lordship is not bound by the coordinate bench.
No, definitely. I'd like to point it out. The judgment relying the.
So what you want to submit?
No, Lordship, the judgment, the Kolkata High Court judgment, already considered the before the learned single judge coordinate bench. I have already provided that judgment. That is, I'm just pointed.
So-
What he
No,
is
sir.
going to submit, the Kolkata High Court, that was earlier in bail application, which was already considered. It was already in, he made that submission in that case also.
So you are
Did
saying
not get it, Lordship.
I'm also not understanding what.
No,
I'm not
Lordship.
following you.
No, Lordship, your citation, Lordship, he is showing the judgment, Calcutta High Court.
Kolkata High Court, yes.
Yes, that was already considered. The judgment I have
Coordinate bench.
by the coordinate
So-
bench, the judgment I have given.
It's okay.
Oh, yes, that is that I have to point it out, Lordship. Just I,
He is saying, Lordship, that the coordinate bench judgment, in that case, Lordship, this Calcutta High Court was shown. It was considered and after,
Shown by the prosecution.
yes, and
Acha.
yes, it was not considered by the coordinate bench. That is his submission. That's okay, I can always make.
yes,
That has already been considered by the court. But
Yes.
it was not considered.
Yes,
Okay, your submission is there.
yes.
Yeah.
It's okay.
yes, Lordship, this is a judgment of the Calcutta High Court Division Bench, Lordship. Lordship will kindly come to second page. The issues were three prone, Lordship, but I will stick to the point in hand. C, second page, point number C, down below, Lordship will find second page. Point number C. Lordship is found in the second page.
Yes, it's,
Yes. The memo of arrest does not contain any column. As such, no signature of any family member of petitioner or a respectable person of the locality was obtained. This is in breach of the provision of section 41B CRPC and the mandatory direction of the Honorable Supreme Court in the case of DK Basu, so and so. When the accused raised doubts on the mode of arrest, contending that the arrest was not made in the manner claimed by the prosecution, the requirement of complying with section 41B CRPC assumes great importance and non-compliance therewith dilutes the restriction in section 37 of the NTPS Act. In this connection, reliance was placed on the following decision. So this was the submission made by the accused in that case. Now, Lordship will kindly come to paragraph number. Paragraph. I'm sorry, Lordship, just a minute. I'm taking a minute, Lordship. Just. Paragraph 15, Lordship. I'm sorry, Lordship, paragraph 17. Paragraph 17, I'm sorry. Lordship has found it? Yes, paragraph 17, Lordship. The third point urged on behalf of the petitioner is that section 41B CRPC was violated at the time of arresting the petitioner. This is because the memo of arrest does not contain any column X. Therefore, no signature of any family member of the petitioner or a respectable person of the locality was obtained on the memo of arrest. This is also in breach of mandatory direction of the Honorable Supreme Court in the case of so-and-so. It was submitted that non-compliance with the so same submission, Lordship. Next paragraph, Lordship, paragraph 18. It is true that section 41B of CRPC, which prescribes the procedure of arrest and duties of the officer making arrest, says that while making an arrest, the concerned official shall prepare a memorandum of arrest, which shall be attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made and will be countersigned by the person arrested. This was reiterated in the case of DK Basu. However, Section 37 of the NDPS Act was not an issue before the Honorable Supreme Court. The non-obstante clause in Section 37 gives the section overriding effect vis-a-vis all provisions of Criminal Procedure Code. In my considered opinion, even when an arrest is made without complying with the requirement mentioned in Section 41B CRPC, still, bail cannot be granted in an NDPS case without satisfying two conditions mentioned in that section. An arrest made without complying with Section 41B CRPC would not per se indicate that there are reasonable grounds to believe that the accused is not guilty of the offense he is charged with and that he is not unlikely to commit any offense while on bail, as held by the Supreme Court in the case of Narcotics Bureau versus Kashif Supra, the provision of NDPS Act, including Section 37, therefore, thereof, must be given a literal construction rather than a liberal construction, keeping in view the object of NDPS Act. Further, the NDPS Act, being a special act, its provision, including Section 37, must be held to prevail over the provisions of CRPC, which is a general piece of legislation, and there the maxim generalist specialibus non-derogant, meaning that when there is a conflict between general and special law, the latter would prevail is well established in law. This is the finding of the division bench of Calcutta High Court. And again, Lordship will kindly take up 36 for a moment, Lordship, BNSS.
Yes.
Yes, 36 Lordship is we are concerned with section subsection B. Prepare a memorandum of arrest which shall be attested by so and so. 2. Countersigned by the person arrested. Now Lordship will kindly see C, clause C. Inform the person arrested. Unless the memorandum is attested by a member of his family that he has a right to have a relative or friend or any other person named by him to be informed of his arrest. So unless Lordship, they must inform the person arrested about his arrest unless the memorandum is attested by a member. So the meaning thereby, Lordship, if the memorandum is signed, then he need not be informed. That is the meaning. But in this case, Lordship, it has not been signed by any other family or family members, but he has been served with 47, 48. So Lordship, the compliance is there. The intention has to be there, Lordship. It is clear from subsection C, Lordship. Once again, I am reiterating, Lordship. Inform the person arrested. The arrested person should be informed about his arrest, unless the memorandum is attested by a member of his family, meaning thereby, Lordship, that if the family members are informed, then he need not be informed. But in this case, because the memo of arrest was not signed by any other witnesses, he has been served with 47 and also 48 has been given in the case to his relative. 48 has also been complied with. So in that regard, Lordship, there is no violation, Lordship, and this been a procedural mistake, Lordship. The intention has to be seen. It has come from DK Basu to custodial debt and all that aspect. Here, Lordship, we are dealing with NDPS, section 37 has to be there. So that is my respectful submission. So even if, Lordship, the coordinate bench has taken the contrary view, Lordship, Lordship is not bound by it. So I'm submitting to Lordship.
Lordship, yes. Lordship, to countering my learned submission, Lordship, both the Lordship 36, 47, 48 are independent sections. That has to be complied with Lordship independently. That is the law. That is why I referred section 62. The arrest has to be made strictly according to the Samhita. What Lordship from the statute, it is very much clear that it has to be dealt with in that way, Lordship, not otherwise. Not substantial compliance. It should be strict compliance, as per my humble understanding and as per the statute. And secondly, Lordship, referring section 5 of the BNSS, Lordship, that is, Lordship, we all always know, Lordship, the procedure of arrest is always followed from the BNSS, Lordship, from the Code of Criminal Procedure. So, Lordship, in that respect of 37, while the arrest itself is invalid, question of 37 will not come, Lordship. So, apparently, Lordship, the accused is, Lordship, will get the benefit, Lordship. This is the only on for procedural leaves, Lordship. And Lordship, Lordship, I have also annexed two other judgment on the same line in the my petition, Lordship. That is page 38 onwards on similar grounds. That is my Facebook.
I'm obliged.
Huh? Okay, okay.
May it please your lordship. My lord, item number 4, lordship, service is complete, lordship. And since lordship, the other matter, item number 5 is analogous to that was filed with the claimant respondent for enhancement. That was, there is a delay, lordship. In this case, item number 5, lordship, we are appearing for the respondent. And
It's delay of how many days?
yes, there is a delay of
393 days,
Lordship.
Lordship, but
Yes.
if your Lordship says after the cross appeal, 92 days would come, Lord. There is a delay of 92 days. After the judgment, they preferred an appeal, thereafter we preferred the cross appeal, Lord. This is the fact of the case.
But after the judgment, you?
After the judgment, Lord, the delay would be 393 days, Lord. After receiving the copy, we get 1 month time, Lord, to file cross appeal, Lord. In this case, Lord, the copy, we don't have a specific date on which the copy was served, Lord. In the judgment is of 17/11/2008, they have preferred appeal on 12 to 2019, Lordship. Thereafter, their appeal was registered on 18 to 19, Lord, and notice was taken by them on 29/6/2019, Lord. So if we count it from 29/6/2019 also, Lord, my delay would be not more than that, 92 days, Lord. So I'm sorry, Lord, it will be around, we have mentioned it at page number,
Where you have mentioned?
yes, Lord, very specifically mentioned it, Lord. So, in the grounds. Page 5 of my appeal, I, Lord, I 2093, Lord, page 5. Lordship, I, page 5.
Page 5 I have.
Okay, 108 appeal was filed on 12 to 2019. The aforesaid case was listed before this court on 27/4/2019 when admitted notice was issued. In pursuant to the aforesaid order 27/4/2019, the appellant took step on 26/9/19. In view of the aforesaid fact, limitation to file cross appeal cannot be said to have arisen before 29/6/2019. And thereafter, my lord, we have
Which para? Which para?
paragraph 4, my lord, page 5 of I, my lord. And para 8, my lord, the whole delay has been explained, my lord. Paragraph 8, para 16, page 8, my lord. So when the cross, my only submission is, my lord, when the cross appeal is already pending, my lord. So why not, I may also be heard whether there is a scope of enhancement or not. That is not done, my lord. They have been 2020 matter. 25, they are asking for time to file, my lord, affidavit in opposition, my lord. Cost has to be imposed. But they are appealing from earlier only, my lord. What stopped them from filing the I, my lord, limitation? Lordship may fix it that is
Your condonation I is numbered as
2093, my lord,
or
of 2020, my lord. 5 years, my lord.
So who are you, in fact? Owner.
India Insurance Company.
Two companies are here.
Yes, yes,
Two
Lord.
vehicles are in.
My learned friend is appearing for response number 3, Lord. Opposite party number 3, I'm appearing for opposite party number 5, Lordship.
Lordship, last opportunity they may be granted. Lord, I will have serious objection, Lord, but if they want, let it come on 12th of February, Lord, in that view. But this must file, otherwise the matter should
Which
be
company is directed to satisfy the above?
Lordship, the New India Swings Company.
You were direct.
50% was direct.
50%.
Yes. It's a 50-50, Lordship.
Both the company.
Yes, yes.
So otherwise, regarding the delay, you don't have any objection.
I have also objection, Lordship.
You have already filed your
No,
objection?
no.
You're going to file?
Yes, yes.
But obviously Lal is saying that it is a matter of 2020.
That is correct, Lordship, but the explanation, Lordship, will find that it is not a, first of all, it is not a cross appeal, Lordship. It's a
Yes.
independent appeal. So if it is an independent appeal, then it will count, the time will count from the date of judgment, that is 2018, 17, 11, 18. In that way, they have filed in the year 2020 in the last part. There is no explanation. And from the COVID is there. We are not opposing the COVID. COVID is okay. But after that, what you did, you have filed wakalat number in the year 19, then after that, till 20 last, waiting for the thing. After receiving the order from this honorable court, dismissing the stay petition filed by us, they have filed for withdrawing the, for vacating the order. There was no stay so far as my company is concerned, my appeal is concerned. After that, they have filed this, Lordship, the appeal. This is not process.
Lordship, let it be on 12th of February. My learned and so serious objection, Lordship. Let it be on 12th of February. Let Lordship may observe that on that day hearing they must file before 1 week, my Lord, and so that we can do the hearing on that day.
This
That is the only
court
submission.
will direct, na?
26, 2020 from 2026. This is on 12th of February the hearing is done also. I am satisfied.
Yes,
In item number 4,
four cases ready, Lordship.
cases ready.
Cases ready. LCR has been received, Lordship. Cases
But they
so
must
this
file-
was
Item
the-
number 4, you are for the one.
I'm for.
Yes, claim.
And all are completed, na?
Yes, yes, service is complete because of this case. Lord.
So we have received here the LCR. also.
Yes, LCR.
Only till
Item number 4 or update your cards. MSN for the Learning Council for the applicant. Also card Mr. A. Lal, the Learning Council applying for the respondent number 1. And you are A. Bora appearing for the respondent number 4. 4. And you're for 5. Number 5. All was for it. Services also completed. LCR has already been received. Matter may be accordingly listed. Hearing. In that case, so it will be a bit difficult if let it be the item number 4 be listed after 4 weeks. Then it will do.
comes-
Maybe taken up together.
together.
Maybe taken up
You
together.
are saying 12th February,
12th February.
12th of February.
And they,
February.
and they may be directed to Miller file it the first week of February, by the first week of February. Within first week of February.
It will be okay, Ms. Chaudhary, for 12th of February,
Can it be on 16th, Lordship?
1/6.
Yes.
16.
16 is Monday, my Lord, 17.
I'm sorry,
17th of
Lordship.
February.
I'm sorry. First date, right? 13 February. 13 February.
13th को Wednesday होगा.
Or Friday. Okay. 12th of February.
12th of February.
12th of February করো আর যেটু IA next to আছে IA 2093 and heard Mr. Hilal, the Learning Council for the applicant. Also heard Ms. Chaudhary for the respondent number 3 and MS Arbora for the respondent number 5 and Mr. Olaskar for the respondent. It is submitted by the Learning Council for the respondent that they were going to file the written objection. However, Mr. Lal raised objection and submitted it is a matter of 2020 and submitted that direction may be given to the respondent side to file the written objection on or before. In view of this, the respondent is hereby asked to file the written objection on or before the next date of listing, list the matter accordingly on 12th.
Yes. Must
12th
apply
is for
to.
hearing, my Lord. For hearing.
We'll be hearing on
If it is
the-
there, then we'll be
On it.
there definitely.
I'm already.
Number 6.
May I please, Your Lordship? Lordship, as per last order, we have taken step register speed post, Your Lordship. And the same has been returned back with the reason insufficient address, Your Lordship. In this case, Your Lordship, my humble submission is that TCL has also received by this honorable court and in the main case, your lordship, in lawyer court below, the respondent number 1 and 2 has had ex parte order. So matter may be had presumed to be sub in respect.
Hard ex parte order means what is some?
Lordship, in respondent number.
Here you have 3 respondents.
Yes, lordship.
Isn't it? So
Respondent
out
number
of
1
3, one you have appeared for?
and 3.
New India Assurance. Three.
New India Assurance
Respondent number
3.
Respondent number 3.
Respondent number 3. And
1 and 2.
1 and 2 is still awaited?
Yes.
1 return.
Data.
So what your submission?
Lordship may be presumed to be sub. We have taken a step through speed post, your lordship, which has been returned in respect of respondent number 2, your lordship.
No, you have collected your
Track consignment I have collected.
track consignment report you have
Yes,
collected.
boss.
So file it. Bring it through. I've just shorted 1 week I'm giving you.
Oh, lordship.
No, if it is already supposed in your case, if it is, you have already collected your track consignment report, that may be collect এইটো নহয় ৰেজিষ্ট্ৰিও দি দিব নেকি?
Can I refer this one?
তেওঁলোকে এখন এফিডেভিট আমাক দি দিয়ক। You are Mr.
SI Akan.
Heard Mr. S.I. Akan, the learned counsel for the appellate, and also heard your Mr.
S. Shom on behalf of S. Datta.
S.
Shom.
S. Shom appearing on behalf of Mr. S. Datta for the respondent number 3. From the office note dated 7/1/2026, it is in that this on respondent number 1 return answer with a postal remark in inverted comma insufficient address, and the notice for the respondent number 2 is still awaited. Let the service be awaited till next listing in further considering the submission made by Mr. Akan. The appellant may file the track consignment report through an additional affidavit on the next date of listing. List accordingly after 1 week. Or after 1 week, we are only listing. You just file it an affidavit.
Lordship. Sublice. Please.
Wait, please, Your Lordship. My lord, in item number 7, respondent number 2, who expired during the pendency of the appeal, was substituted as per the last order. Now, my learned friend got time to obtain instruction whether he can appear for the substituted legally.
Otherwise, you are appearing for whom?
I am appearing for respondent number 1 and 2. Your
And
Yeah.
who died?
I have a
2 died.
2 died, Your Lordship.
So if you have any instruction,
Lordship, I can appear, Your Lordship. I have obtained instruction, Your Lordship.
you have already obtained instruction.
Lordship.
So you can appear.
Lordship. So I will file my wakalat on my.
If you're going to file your wakalat or already filed?
No, not
You're
yet
going
filed.
to file.
I am going to file.
So 2A to how much? 2A?
No, only 2A.
Only 2.
Only 2.
Only 2A. 2 died, now 2A will be the substituted respondent. Otherwise, the appeal was admitted, the decree, impugned decree has been stayed. So it is ready for hearing, records are also here.
Heard Mr. D. Chakraborty, the learned counsel for the appellant, and also heard you are Mr. C. Borva.
I am R. Borolo.
R. Borva. Also heard Mr. R. Borva.
Borology.
R. Borva, the learned counsel appearing for the respondent number
1 and 2.
1 and 2. However, after that of the respondent number 2, the legal heirs of the respondent number 2, that is 2A, has already been completed, and it is submitted by Mr. Borot that they have instruction to appear for the respondent number 2A. However, he submitted that he will be filing his wakalatnama shortly. The LCR has already been, TCR has already been received, appeal has already admitted. This matter accordingly for hearing. After 2 weeks will do, you will be appearing.
Lordship.
2 weeks or 3 weeks you need.
Anything
You can file your wakalatnama.
Lordship, we can file. We did not.
No, within short period you file your wakalatnama for hearing, I'm saying.
For hearing, Lordship may fix it in the month of March. Your Lordship.
In the month of March.
March.
You want any fixed date here or on the first week of March?
Any date, Lordship may.
Otherwise, my lord, earlier there was an order that the hearing would be in the due course, but if there is any urgency, my lord, it can be fixed in the month
10th of March.
10th. Obliged. Obliged.
Please, your lordship.
Yes. Here,
Office note reveals, lordship, the notice upon respondent number 1 is still awaited. The LCR
one and
1 and 3. The LCR has also not been received. LCR may be called for.
they have already been received. It's still awaited LCR.
Still awaited.
And 1 to 3 are awaited. Nah?
Yes.
So let the service be awaited. You are Mr.
J. Das Gupta, lordship.
Or Mr. J. Das Gupta. As per the office note, dated 8/1/26. The service for the respondent number 1 to 3 awaited, and in the same time, the TCR has also not been received. Issue reminder: the raised will do the need service be awaited till next date of listing. Raised the matter according to 3 weeks as on a date.
Much obliged, lordship.
May it please your lordship. Lordship, in this case, we have forgotten to take step inadvertently, lordship. May grant us 1 week time to take step and let the matter come after 6 weeks, my lord. MAC appeal already admitted, the notice was issued, my lord, but order dated 18/12/2025, lordship.
Mr. Taylor, the learned counsel, it is submitted that inadvertently could not take steps for the respondents, and accordingly some time may be required for the same. Prayer around, issue notice to the respondents.
After 6 weeks, lordship.
After
6 weeks.
it will matter be listed after 6 weeks. As on a date fixed by the minister.
I'm ordered.
May I please, Lord? It's a very unfortunate case, Lordship. There is a interim order from the trial court protecting my right. Then there is an order from the High Court in the heart of the city next to my home, Lordship. Bringing gundas at night, Lordship, they have taken possession again. The trial court protected my possession, High Court protected my possession. We went to the police station, we went to the commissioner of police, we went to everyone. None is helping. Lordship, we have the video, we have the CCTV video also. Also, Lordship, this is not done, Lordship. After an High Court order, Lordship. Lordship, this is an application under Section 151, Lordship. I want the help from this court, Lordship. They to protect the dignity of the court, Lordship. It is not my dignity only, Lordship. This is something unheard of, Lordship. Lordship can see. Lordship, may please
Okay,
come
in
to.
that connection, you have filed one IA here.
Yes, today. And
Okay, yes, what is
Lordship, I am led by Mr. Senior Advocate D. Das.
D. Das, yes.
Yesterday they have filed this application. We have received this. So we want, as per the instruction, we want some time to file an objection in this application.
No, but
No,
what
let
is the
this status-
position of this case now these, as per you, they have brought some the
Gundas and take my position, Lordship. That cannot be, Lordship. They will take time, Lordship, after that. This is something unheard of, Lordship. These gundas are, Lordship, after a trial court order, after a High Court's order, these people are doing this. After, Lordship, may please come to page 50. My trial court order,
It's
Lordship.
okay. No, it's okay. The question is that now see, as submitted by Mr. Sharma, the matter may be urgent, so a hearing should be there. Otherwise, also the item number 16 is fixed on for hearing.
Yes, Lord.
So
We have-
now
we have received this copy yesterday itself. So
Yes, that is why I have given yesterday.
We have some time
we need some time to file objection because the statement which is made here is totally false.
Okay, then Lordship, the status quo and to be restored. Lordship, any time, Lordship, 1 month, 2 months, whatever they want, Lordship.
Last order, this honorable court has granted status quo order. Let me
Yes.
continue. The
Yes,
status
we'll see the video, Lordship, then. What was the last order and what is the, Lordship, Lordship, in 111, my PA is there, Lordship. Let us see the video. What these people are doing in the land. I have annexed the video, Lordship, in my petition. How they are entered. All the vehicle number, yeah, everything is there, Lordship.
Lordship, 1 week time, we'll file objection.
Status quo was there.
Yes, status quo is there.
Well, Lordship, no, that before that, Lordship, the trial court has protected my right. Trial court said we will continue.
No.
Then they have come on appeal.
Lordship, a trial court
Lordship, the
has passed
trial
an
court
order,
passed a specific order.
and
They
we
come
have
to
come
the
for
High Court.
appeal in this court.
High Court has
this
given
court.
trial court order. They have not got a stay order from this court.
The trial court
And
has passed
after
an
that, they have
order.
entered
Court
into
has-
the position.
This honorable court has granted a status quo order.
Yes. Then
Thereafter,
they will violate
they,
this
they
status
have
quo.
filed this application yesterday. I am just praying 1 week's time to file my objection in this case.
With the
Status
position.
quo was there.
Yes, status quo order is there.
In my favor,
We
Lordship.
have filed the application. We have filed the FAO.
No, you have filed the appeal, I
The
understand.
status quo is in our favor.
Lordship, the is laughing, Lordship. The Lordship, may please come to page 62. What is the status quo order? Let us see. In my application, Lordship. My application, Lordship. Lordship, you can see the videos, how they have entered.
Now the
These
questions are.
gundas, how they have
Page number
entered the
six-
possession. Let us see.
Lordship, page number 62
There
is
should be
a
some limit of
photo
gundami.
from some
Vandalism.
This is the photo which my learned senior friend is stating. This doesn't mean anything. I can place a board and I can take a photo. There is no section 65 IT application whether these photos are authentic or not. Nothing is there. We have serious objection in this case application.
Okay.
We want to file objection. That's why I pray a short time from this honorable court. Soon after reopening, let the matter be fixed. We'll file our objection in this case.
Reopening?
What kind of reopening?
There is, after 26th,
Lordship, may please come to my trial court order, Lordship.
after 26th,
This is not done.
27th, we'll file a objection.
Now, question is that I don't know. I have not done through the
Lordship,
report because I was outstation. Now,
Yes.
question is what is there? Now, there is a status quo order.
Yes.
I don't know where is there now. Who is in position?
We are in
I'm in
right?
position, Lordship, all along. Lordship, that is why, Lordship, may please come to page 53.
Suppose Mr. Sharma is in position. So whatever status quo is there. So now the I has been filed alleging that you have entered with some gundas and all to the
Yes.
premises and trying to.
Yeah, we want to file objection in this case. That's it. So some time should be given to us to file objection because
So now do one thing.
Yes, sir.
Suppose if status quo is already there, I don't know who is under position.
Yes, Lord.
Maybe you are claiming that he is
Yes.
also claiming this position.
Yes, Lord.
So if status quo is there, let the status quo be maintained till
Lord-
next day.
Lord,
So that you can file. Otherwise, now see, this is matter is for hearing only.
yes, Lord.
So definitely they have filed one IA yesterday or today?
Yesterday.
Yes,
Yesterday, so I have received. You
yes.
know. But now question is, if you file the objection here also, suppose I am saying,
Yes.
that objection and the entire appeal will be heard together.
Yes.
Because what will the position, what is this thing, then only we come to know.
Much obliged.
Some photographs they have taken, some videos also they have
Yes.
submitted that there are some videos.
Yes.
I don't know, we will going to play or everything will be heard.
Lordship.
So now that is the question. So you need 1 week time.
Yeah, 1 week time. 27
Let
Lordship
me
may
book
fix the
Mr.
matter.
Sharma, 1 week
No,
time.
Lordship, the 1 week, 1 month, I don't mind, Lordship. Lordship, it is the dignity of the court, Lordship. Two court protected my right. Lordship, may please come to page 53 of my miss case, Lordship. I'll show, Lordship, how the court protected my right. This is not done, Lordship. These gundas will enter in the heart of the city like this after the court's order. And videos are there how they have entered at night, showing my people from the land. Videos are there, CCTVs are there. Everything is there. Why they will continue for 7 days? Taking time?
7 days in a sense, today, only 2 days left, I think. Tomorrow and day after tomorrow. Then 4 days, 5 days, only days. But by that time, if suppose any further construction.
Status quo. what
Then
we
lordship,
say,
then
Lordship.
lordship, the head breaking lordship. If lordship will not protect me, lordship, then will be head breaking lordship. I am telling in this court, lordship. Okay. Not
No,
protect.
no, I'm
No,
not.
lordship. Then
I'm asking you, yeah, already the status quo was there.
Yes.
So what kind of
If
order
this-
do you want
if
now?
if this way the people can enter into the possession, I have the video, I have the CCTV. If lordship will not
You
protect me,
want
what
hearing
I'll do?
Tomorrow you want hearing.
Yes.
Will you be able to?
Lordship, senior counsel is not.
Whatever senior counsel, what senior counsel, then let them send the senior counsel. I may not be there tomorrow, lordship. This is not done to protect the right of the people, lordship.
Lordship,
Two courts order, lordship.
27, soon after reopening, 27. We'll file an objection to this application, at least it can heard in finality.
Why lordship do not want to see my miss case? I do not know. All these photographs are there. After looking, lordship, in the last date order, lordship can see the last date order. First.
Last date order in FAO.
Yes.
Okay, that I have seen.
Yeah, hold on. Page 60, lordship. Page 60 in my miss case, lordship.
Yes.
Lordship, get it? Page 61. Heard so and so. Till the next date of listing, both the side directed to maintain status quo as regard the suit land as on today. The photographs given by the respondent shall form part of the record. I have given the photograph. So from the next page, lordship, page 62. All these photographs are there in the record that I'm inside. And lordship, this with all this GPS timing and everything, lordship, in this photograph. Lordship, may please directly come to page 75 and 76.
See, we have serious objection with regards to the photographs and all. On the last day, senior counsel have stated this fact.
So now by this IA, what is your prayer here in the IA?
Hey, lordship, the prayer is to throw them out and yeah, lordship. Put me on the position, lordship. Page is started at page 29, lordship. Pen drive. Pen drive, after 9. Pen drive code लगा है अपना. মানে তাতে উলাবো না? হ্যাঁ? এটা কি উলা? একো কাম নাই. Pen drive code লগাই. আমার 100 and page 111 pen drive to আছে. How they have entered into the position I have given at page 111, my pen drive is there, lordship. All the CCTV put in. All drunk people, lordship, all drunk. With marks. This is the video, Lordship. Lordship can see. What is there in the pen drive? It is there. If Lordship, they can do that, we can also do that. All right, tonight I'll do. If Lordship, no, okay, Lordship, yes, if I will not be protected tonight, I'll do. I'll definitely give my client advice. Go and take the position. Yes, Lordship, if the court will not protect me, then definitely I'll say to my client that go and let the head breaking be there. Yes, 91, 92, how they have entered, they have given colored photographs. Their photographs, my photographs is okay. How they have entered now. Their Gunda's photograph is there on the land now.
Now, see, it is a very serious allegation brought against you.
Yeah, we want to
There
file
is-
objection
the
in this.
Status quo order is there.
Yes, Lord.
So let the status quo be maintained. So why are you there with your gundas and all?
No,
Suppose
no,
this
this
was
is
an
just an allegation, Lordship. I will file an objection in this case.
No, the allegation along with the videos and
No,
photographs,
but
they
it
have
is,
already
it is
submitted.
not supported, Lordship. I have to file objection, Lordship.
Lordship, let them.
I am completely denying it. I will be filing objection. That's why I prayed in the first instance, Lordship, that I will be filing a complete objection. I may be just given time till 27th. I am not asking a long time.
Lordship,
Till
let
next
them
month.
show.
Only till 27th.
Let them show from the first appeal one line that on the date of the filing the first appeal they were in possession. One line. I'll go out. I'll withdraw my. Let them
Lordship,
show
a
one line
submission.
from the first appeal that on the filing of the first appeal they were in possession. One line, Lordship. The trial court protected trial court order, Lordship. That is why I am saying, Lordship, please come to trial court order. What the trial court has said. Page 57, 58.
Of your IA.
Yes. There should be some limit. Page 57, Lord.
Yes.
Lordship, para 21. Let us read slowly to get the thing, what is there. So without going into the merit of the respective claims over the property, what it appears that the suit property is in danger of being wasted, damaged, and susceptible to the change of hand. Now, the complex and particular factual matrix of the case necessitated the intervention of the court in the form of a temporary and mandatory injunction against the plaintiff at this stage. Any order of denial of temporary injunction at this stage may cause irreparable loss and injury to the petitioner, defendant number 2, my client, Lordship, and will lead to multiplicity of proceeding. Further, the plaintiff cannot be allowed to remain in possession as it will amount to allowing a party to take benefit of its own wrong. In fact, Ms. J case number so-and-so, the plaintiff while admitting possession, Lordship will see, in so-and-so, the plaintiff while admitting possession of the defendant number 2 have prayed for temporary injunction restraining the defendant number 2 from alienating the suit land and proceeding with any construction over the same till disposal of the suit. Now, therefore, what the court has given, para 22, considering the above facts, the court hereby direct the plaintiff to keep their hands off the suit property and not to interfere in possession of the defendant number 2 till disposal of the suit. Right? This is the order. They came for the appeal. Now status quo. What does it mean? What does it mean? How they have entered into the position now? After this, Lordship, get it? After this, their appeal. In their appeal, Lordship, in the first appeal, whole first appeal, Lordship, huge ban. Let them show that we are in possession on the date of the filing of the first appeal, a pleading or in the IA. Let them show that at the time of the filing of the first appeal, you were in possession. This is my possession, Lordship, from one court. The second court, High Court, now, the second one. Now their appeal, page 60, High Court has given page 61. In view of this, continue the status quo. And then what the High Court said, whatever photograph you have shown, High Court said the photographs given by the respondent shall form part of the record. So after this, Lordship, the trial court, Lordship, in the paragraph 16, has considered everything at page 53. These are the dot point. Everything she has considered. Appeal. Appeal said, no, nothing doing, will not interfere. Then if the High Court interfered and give a stay, that's a different matter. Not given. This should continue, Lordship, the para 22 at page 58. What will happen to this? What will happen to this page 58, para 22, after considering everything, after hearing both the parties? And Lordship, what happened? At the time of the filing of the suit, in the prayer, they've asked for recovery of possession. What more is required, Lordship? Lordship, during the time, for a long time, Lordship knows in a title suit, if you want a recovery of possession, what does it mean? That the defendant is in possession? Then what happened, Lordship? In the meantime, they enter into the possession once again. That is called during the pendency of the suit, they entered into the possession again once. Trespass, trying. And they have filed an amendment then. That now we do not want the recovery of possession. And that amendment is rejected by the trial court. Trial court said nothing doing and there is no appeal. Lordship will not believe it. There is an amendment application then.
That was
To amend it, and that was rejected. And attains finality. And attains finality. That's my point, Lordship. So my right be protected. Let them take 1 month time. I have no problem. In the name of the senior, in the name of the whatever, Lordship, I do not know.
Oh, he's there.
Lordship, let them take time. What the this page 58, Lordship, what I have shown,
I have seen.
that's fine.
Now they have filed one IA. So otherwise,
Lord, I don't understand.
No, yes,
Am I not entitled to get a reply, small reply, a week time?
Definitely.
So, my lord, I have not come across that today contempt application has been filed. Order 39 to waive a violation of the court's order. Very well. That your lordship will definitely has to look into it. But my objection has to be on record. And your lordship, in the matter, when we filed this FAO, this matter was heard. And there was an interim order which has been the status quo as on today's elemented. Now my learned friend has come to this court filing an application that there is a violation under Order 39 to waive. Very well. My lord, we have to give an objection to it. Thereafter can be heard. So what my prayer is that I have asked that we are not taking much of time. But normally 2 weeks, 3 weeks, I am saying that if there is an urgency, I take about 7 to 8 days time, 1 week time. Time should be given. I will give a reply to it. Independent interim order may continue. Otherwise, your lordship will, without hearing me, without giving an objection to it, they filed this application yesterday. At least 1 week time, I should get it to give a reply.
Okay, now otherwise it's okay. You should get time, and definitely you'll need some time to make your reply because there are many photographs now also been annexed.
Yes.
Now the question is that as per Mr. Sharma's allegations, now you have entered into the application and started his.
That is his allegation. My lord.
So that's why, and otherwise also there's an order for maintaining status quo by both the parties.
Yes.
So now at this stage, we don't know whether there was any violation of the court's order. The allegation is from their side that there is a violation.
Right.
Gundas and all you have entered
Right.
and you have submitted them. So now Yes, definitely you should get time that in the
So
meantime.
my prayer, before your lordship is that there is already an order. Suppose today my lordship pass an order, some different to that. So there is amount of modification of the order. There's amount of modification. So my humble prayer is that the order which was earlier let it continue till the next day. And next date can be fixed after a week. I am not asking for 3 weeks to file this reply. A week time, man. After weekday, I will serve a copy in advance. 1 or 2 days in advance will serve a copy. Thereafter, matter can be taken up. If your number one, if your lordship feels that number one, there is a violation of the course, the appropriate action will be taken. Independent hearing can take place. Entire hearing can take place.
Enter hearing.
Hearing can take place. Entire hearing.
Lordship may please come to page 58.
50.
Page 58,
1-5.
58.
No, that I have seen already. You have.
So that should be there. And Lordship, we had a prayer, let the Deputy Commissioner go and see whether this position is there or not. Because this para 22, it is very clear, considering the above fact, the court hereby direct plaintiff to keep their hands off from the suit property. There is no stay order. So there is no stay order of this. My possession is admitted in the FO.
itu jadi kan connection है 22 I don't know civil 95 of in connection with Mr. Sharma, senior assisted by Mr. A. Gordon, the counsel for the applicant, respondent, applicant, and also heard Mr. D. Dustin, senior advocate, assisted by Mr.
FRED.
FRED for the respondent. It's an application, section 151, read section 21, read order 21, rule 35.3, and order 39, rule 2A, capital A of CPC for urgent interim and ad interim directions for restitution of the status quo. Anti-order dated 26/11/2025 in the present. And it is submitted by Mr. Sharma that in spite of this order of maintenance of status quo passed by the on 26/11/2025, there is a violation of the order of the court, and with some the gundas and all, they have already entered into their premises, wherein the petitioner or the applicant had already has the protection right over the property, as granted by the learned trial court below, as well as this court by order dated 26/11/2025. Next part, Mr. Das, the learned senior, submitted in this report that they have filed the present I on yesterday, and accordingly he needs some more time to file his written objection. And apart from that, it is also submitted by Mr. Das that there is no violation of the order of status quo passed by this court on 26/11/2025. Be further submitted that this 1 week time may be given while this written objection. Mr. Das also submitted that the hearing of FAO also may be heard, and then the FAO connected FAO, that is 75 of 2025, may also be heard on the next day. Next part. After hearing the submission made by the counsel for the both sides, it is seen that after counsel partly Mr. Sharma, the learned further stress on the order passed by the learned trial court below dated 6/11/2025, wherein the court observed that the present applicant is in possession of the land, and accordingly in para 22 of the said order, it has been held that in para 54, it pays 58%. Para 22. Against the said order, they have come up with a appeal, wherein also the order of maintenance of status quo has been passed by this court on 26/11. It's submitted that matter is very urgent, as they have already violated the court's order and entered into the premises, which is still under possession of an applicant. Considering the urgency of this case and considering the submission made by learned counsel for both sides, vis-a-vis the order passed by the learned trial court below, as well as the court as well as by this court, both parties are hereby directed to maintain status quo over the suit property, as already directed by this court, dated 26/11/2025, and it is further strictly directed to both the parties not to make any
No, it's
strictly to maintain status quo over the suit property till the next date of listing, and the other respondent side is also hereby directed to file a written objection on or before the next date of listing, as no further adjournment will be granted to the respondent side. This matter accordingly 27/28 will do 27, because sounding the matter is
28
supposed to be urgent.
is Wednesday.
Huh?
How my learned friend is, this is important. 27 is, 28 is
I have not said any date, Lordship.
27.
Whatever their convenience, Lordship, they can do anything and everything. They can take possession of in the court's order. So they will, whatever they want, they
That
let
is
them
not
get.
it. That is not it. 27 is a monthly date. Tuesday.
Let the court go by their.
Then you can Tuesday. Or court is ready to hear if you are ready to file the objection on tomorrow or day after tomorrow. We are ready.
No, 20, at least 1 week we need time. So 27.
Lordship,
27.
then direct the,
27.
then direct the Commissioner of Police to look that whether this para 22 is there or not.
That cannot be.
That
done.
Lordship,
So
my friend is
insisting.
there, Lordship.
My lord, that's
Commission
I-
always, Lordship can lie, then Lordship, I'll go to the Supreme Court.
27.
Lordship, I'll place some Supreme Court
No,
judgment.
let it be. Let it be. Go.
Lordship, I'll place some Supreme Court judgment on that. Lordship, no. Lordship, there should be some commission. How come they will continue in a position, Lordship?
Your
In
lordship,
violation,
there
Lordship?
is a 27.
How come, Lordship?
Status quo order.
No,
is
Lordship,
granted.
what the trial court has given specifically.
It's not that.
How come they will enter into my plot, Lordship?
That's why we don't address in shouting way. Let us be.
Lordship, Lordship,
let
page
us not-
75,
let us
76,
not
Lordship,
blame, my
see.
lord. Let us
Lordship,
not-
still, say page 75, 76, I'm there.
The way I am asking for a little accommodation. My learned friend has to understand. What is saying that
Accommodation, you
it will
took
go
1 month, I
it will-
don't mind.
What is saying it will go according to your choice? How it is a choice of the court? It is not our choice. We can make a reasonable prayer of 1 week. I am asking. I'm not asking for 2 weeks.
No,
time.
Lordship, what the
We
Lordship
don't
want?
take
Lordship,
personally.
if Lordship,
My lord,
they can
if my
take
learned
the
friend-
possession like
if-
this. Then
let-
my client can also take the possession like this.
my lord,
Okay, let them be,
my lord, we
let them be headbreaking
My
in
lord,
there.
we don't
If they
go-
can do this, why not my client, Lordship?
My lord, we don't go by emotion in the court.
Why not?
Let us go. If emotion doesn't work in the court, let
Oh,
us
then
see
gundami
what-
and
My- let me
vandalism will
myself.
work in
This
the
is
court.
not the way.
This is
My
the
learned
gundami
friend
and
is a senior
vandalism will work
counsel.
in the court.
My learned friend is a senior counsel. He should not.
It's-
My lord, we should.
no, Lordship.
All juniors.
I have
Yes.
shown, I have
No,
shown the
don't,
video.
please.
I have shown the video.
It's okay.
I will
Your-
never suggest my
lordship-
client to take possession
My lord, your
by
lordship-
gundami, Lordship, by
Your-
vandalism, Lordship.
My lordship.
After
is-
the court's order, I will never suggest my
my lord,
client
nobody is
go and take
suggesting-
the possession by
nobody is
vandalism.
suggesting, let it be.
As a senior
Your lordship-
counsel, after wearing this gown,
Very well,
I will
very-
not suggest
very
my
well.
client to
Don't
go
suggest.
and take the possession
Yes.
at night showing gundasm.
My lord, this is not not a place of emotion.
It's
That's
not
all.
a place of,
Yes.
it is not a place of
Your
gundami
lordship has
also,
fixed
lordship.
it on
If
27th.
after showing
your
this
lordship will hear.
video,
Yes,
if
that's
after
all.
showing this video,
That's all.
someone can do this
That's all.
gundami.
That's
After
all.
the court order, court, please see the page 75 and 76.
That's all, my lord.
That is why
I'm just-
repeatedly I'm saying,
Yes.
my client is there inside on that day. How dare, now I'm not there? How come? After the protected by the trial court, after the protection of the high court, because there is a vacation, I suggest that now there is court vacation, you go and take the possession at night. Send some gundas.
Possession in a sense they have entered and what they're doing now as per you?
Picnic, lordship. The video is there. Inside they are doing picnic. Video is there, lordship.
My lord, this
Video
was
is
our
there, lordship.
allegation. Let me come with an objection, then we'll come to the one side is going on. We'll also file an objection to it. Then your lordship will
That
decide
is
it.
why, lordship,
One
an
side doesn't
independent,
happen.
they let their
In
independent
the
authority go and see.
No, one
Why
side.
two courts order?
one
There is
side-
two courts order. If the gunda can do all this,
don't
why have you
use-
not get that protection,
This
lordship,
doesn't-
that someone will go and see?
My lord, this doesn't.
Why
suit-
someone will not
this
go and
doesn't
see?
suit in
Let the
court.
registrar of the High Court go and see what is going on after the court's order. Why the court cannot look into it? After the two courts order, why I am not getting this protection at least? One registrar cannot go there and see what picnic is going on inside the land. After the two courts order. Even today their car is parked inside.
This is an open space or what kind of?
Open space there, my residence, my home, I have constructed, everything is there. My godown is these are the there. Today's photograph, Lordship, you can see. Today's photograph, Lordship, you can see.
See, Mr. Das, I don't know.
Let the register go and see.
I am not saying anything about the authenticity or every video clipping, but the question is that if this kind of thing is going, it should not be.
No,
as per my
lord,
I don't know
I have
whether
seen, my
it's,
lord.
yes, you are
No, no,
going to find the objection.
see, my lord, what I said. Let me go through it. How can I say now, my lord? Let me go through
Lordship,
it.
this is the vehicle inside.
See, my lord, my
In the- in
learned
the
friend
act, Lordship
is a
can see
senior
the-
counsel. I am also senior counsel. We should know ourselves, my lord. We restrict ourselves. We know. If I think myself,
I
after going-
restricted my client,
please.
Lordship. I
No,
restricted my
no,
client.
you
Don't
may.
go and do gundism
you
in the
may
land.
not, my lord.
I
My lord,
know.
I'm saying.
I know I am wearing a senior gown, so I know. I say that. Don't go.
My lord,
Don't go for head
my lord,
breaking.
my lord,
I have advised my
my lord,
client.
my
to
lord,
that
this
effect.
is what I am
I have
saying.
not advised my
It's
client
up
to
to
take
your
the
lordship.
position.
If this is not the way that you shout and get an order,
Time on
you don't get an order by shouting. That's
No.
all. Yes, deeply
Because
obliged.
that is also,
Deeply
you
obliged.
cannot do like gundami like this and sense
I'm
the
deeply
law.
obliged, ma'am.
Same order,
Yes.
more or less. Yes, we will be.
Now, Lordship, the Deputy Commissioner also has passed an order. We have annexed. Everything is there. Why I am
Let's
not
see.
getting this protection, Lordship? Why a register cannot go and see whether this vehicle is there or not?
Order same order yet people there get hardly hard Mr. Didas and its advocate assisted by Mr. Paridi for the appellate. Also heard Mr. Asham, the learned senior advocate by Mr. The appeal is ready for hearing. However, one I has been filed by the respondent, which is numbered as IAC 95 of 2026 under section so and so with the again we take it same I. Matter may be decided finally on 27. And
Deeply
strictly,
obliged, sir.
strictly. Now see your party is also we are otherwise there was an order for status quo maintenance, but we are strictly ask you to maintain status quo. So
my lord,
I don't know whether this is true or false, whatever.
I will just, I'll get it information now. I'll let your lordship knows what is happening, my lord. That's I will definitely.
Yes,
on the
but
next date, we'll file the objection.
Yes, you file
And
the
I'll,
objection and
yes.
it will come to know everything. But
Yes.
the question is that suppose if your client is doing such kind of thing,
Yes.
suppose I don't know, as Mr. Sharma is
Yes.
saying that this kind of videos are there and all, just ask your clients not to do all these things because there's a court order.
at
Because
least-
otherwise, the order there may be an adverse order against you or against Mr. Sharma, whatever I don't know. So just ask your
At
client
least-
not to do.
My lord, what I said on the very beginning, I said, my lord, I have got the copy, I'll get
Yes,
it.
sir. Yes,
If
yes. I know.
something has been done wrong, definitely I advise my client. That that my learned friend should trust me also, my lord.
No, Lordship,
What he's
Lordship,
saying, that
Lordship,
I am a
at least-
senior,
at
you
least-
have advised, that what he's trying to say.
Lordship,
Please don't say, my lord.
Lordship,
I'll take your
Lordship,
lordship,
at
please,
least,
my lord,
Lordship,
one matter has come up.
Lordship, one thing I can get, Lordship, and one thing I can get, that no one enter the land till 26. Let the vacant possession be there. Why they will do picnic in my land?
Strict compliance, I have already ordered. Passed the order.
Lordship will say do something to police, Lordship, otherwise they will not go. Something
So,
to the commissioner or whoever.
Now, in that case, we have to hear the other, I mean, to hear the other side also. Otherwise, we cannot.
Lordship has said strict compliance.
Strict compliance, I have.
And Lordship, paragraph 22 have quoted.
Yes,
Lordship.
have already.
Yes, okay. Thank you.
Sorry, full lord. Lord, কিমান থাপেছ দেখে তো। একেলগে দি দিব পেছাৰ বুলি। হেৰি বৰুৱা পাঠ থাকে কাদেৰৰ আছে আৰু হেৰি ইয়েছ এইটো উঠাব লাগিব। We want to hear this because it's a part that you
Yes,
know
ma'am.
better. I think.
He may start reading the title applicable judgment. Lordship. In the meantime, his senior may come. He can start reading the judgment.
No, my lord, the matter will pass over for time being.
Now see, this is the part third matter. Part third, if matter is remain part third, that is the difficulty because bench is required
Yes,
and all.
no, my lord, only for
So
pass over.
if we hear the other matter, that it may not reach also. I
Other than
don't know.
After two, my lord.
Huh?
After two.
No, how can I say after two? We will start another hearing, na? We'll start other hearing. That will
he's
be
on-
another problem.
He's on late.
You cannot say that at 2 it will be started. How can you say? That's why I just I talked to the court master that we are going to hear the part third matter specially. Reading can be done. What is your difficulty?
I'm not prepared well, my lord.
No, no, no. We are not. She's not saying that. She says Ms. Chaudhary is saying that reading of the trial court judgments can be done. In the meantime, your senior may come.
It's a concurrent finding, my lord. Therefore, the senior may.
Law points, definitely you will raise the points. That is not the issue. I'm saying that if anything, or otherwise, I don't know.
Just to refresh the mind of us, Lordship, as we have already forgot what was the argument on last occasion, Lordship.
Can you remember the points we have argued?
On the last occasion, the matter was heard on 25th 9, 2025.
I have noted down some points
And
also, which is here with me.
Also, my lord, in the evidence part also may be translated. It is required.
It may not be.
Lordship.
In the evidence.
Lordship, let him come. Lordship.
So sometimes
Evidence-
we are going to start another matter.
Lordship.
Sometimes too, I cannot say now.
After the
If anything is started.
Lordship, if any item, Lordship, in the meantime already closed, then he may come. Lordship.
Obliged. Hello.
Wait, please, my lord.
Yes.
My lord, this is the first appeal.
Huh.
And it is against the trial court judgment of civil judge Dorong. All right. So it is a suit between, I'm just telling the brief. After that, I'll go through the judgment and all. It is a suit between two brothers. Between two brothers, and there are a scheduled property is the totality of B plus C. B plus C is equal to A scheduled property.
B plus C.
B plus C is equal to A scheduled property. And the respondent now, who was the plaintiff there, we were the defendant. The respondent was the plaintiff. So plaintiff is seeking a declaration over the C schedule property.
Yes.
Declaration over C schedule property that he is the sole, he has got it as in his share C schedule property. And he wants to show himself as a good Samaritan, saying that he has given us B schedule property, which is double the size. B schedule is 5 bigha, more or less, and some odd 2 katha is there. That I'm not saying. More or less, I'm telling the main story. On the other hand, he says that I have only got 2 bigha 2 katha.
Now, if B
The
schedule
plaintiff.
land is of 5 bighas.
5 bigha. And C schedule is of 2 bigha 2 katha.
Yes.
Their contention is that as per a Bharwell family partition, Bharwell family arrangement, C schedule is the respondent or plaintiff's property. And our contention is that both B and C, as per our written statement, should be divided 50-50. It is based on, first of all, we have denied that Bharwell family arrangement. That we have denied. And second, we have said that this is, C schedule is a marketplace. And B schedule, although 5 bigha, is a lowland, agricultural lowland, sometimes submerged underwater. And in the alternative, they had another prayer in the plain that if we challenge the Bharwell agreement, Bharwell family arrangement, then they are asking for a partition, 50-50 partition.
For which land? No.
Of
schedule land?
Yes. It is in page number 15, the prayer portion in the plaint. Division of the whole property, schedule A. Page number 15. So, if this preliminary decree is also allowed, had it been allowed, our purpose as on today is also, we are okay. We want 50-50 in B also, C also. So, if A is 50-50 divided, genuinely 50-50, not that we don't need any good Samaritan, we don't need 5 bigha, not necessary. 50-50 in agricultural as well as the market. So, what had happened actually, what had ensued later on in the trial is that after filing WS, our advocate did not appear. So their evidence in affidavit, of course, it is nowadays it is evidence in affidavit, almost copy paste from the plaint. That evidence was accepted in toto. That word is also written by the learned judge. That as there is no cross examination, I am accepting it in toto. And thereafter, I am showing the operative portion of the judgment.
So you file your WS or not? Not you
File WS. That much we have done. We have denied the family, that thing. We have denied that Bharwell arrangement on which they are saying that B is mine and C is theirs. And thereafter, if I come to page 50, very shortly, I am showing the crux of the matter. Page 50 is the last page of the judgment. My lord has got page 50. So here, in a third line, accordingly, a decree is passed declaring the plaintiff has got right title, interest, and possession of her Schedule C. As they have asked, they have got everything they have asked for. But preliminary decree later on, from the bottom portion, 5th or 6th line, preliminary decree is passed for division of Schedule A property into 2 equal shares. Now, this is confusing. If the preliminary decree is this, we are happy enough. But because of the earlier, accordingly, that observation, now that is the problem. Because C declaration is given in his favor. After that, how it can be equal division of A property? So, my lord, that is the exact issue. In very briefly, this is the issue. Otherwise, brothers, it is a between two brothers. We don't want any bad luck to go on for that. But then giving a low land and taking market area, that is also not acceptable. And there is, of course, some problem with our trial court advocate also, who did not appear in the later stages during evidence. And these two prayers, these were in the alternative, or both are granted. Preliminary decree this, that if they contest then this, then that is also granted. The alternative one, the declaration, full declaration, that is also.
Yes.
So my prayer here, it can be two things. One is that it can be sent back for a contested trial, which did not happen. It is not not decreed on contest, number one. And secondly, if a 50-50 share is given, actual 50-50 share, as it is given in this order also, in the preliminary decree. If that is so, then also
No,
we are
this is
satisfied here also.
This order, whether any preliminary decree has been prepared?
The preliminary decree, actually, because of this earlier observation in the judgment, that C is in his. After that, whatever remains is, there is cannot be a 50-50 of A, because he is
No, no,
already
no,
given.
whatever. I'm asking on the basis of this decree,
Yes.
this order, whether any preliminary decree was drawn or it's not there.
Lordship, it is there in page 57.
The decree is already there.
Yes.
Decree is there. No, I'm asking on the basis of decree, that decree, whether there is any
Actually, in on ground.
actual on ground, or whether there is any assessment of any property, whether there is anything.
তার মানে তার মানে
On the basis of the preliminary decree, whether any
এই শিডিউল তো 50-50 করবো লাগে কিন্তু তার আগে কথা বলে সিসি তো ডিক্লেয়ার করলে একটু প্রবলেম হয়ে একটা কনফিউজিং এটাতে অন দ্য বেসিস অফ দিস ডিগ্রি কেউ ভাগ করে দিতে নি কেন
No.
Till
now,
close
my
that.
lord, no partition is there.
No partition.
No.
But on the basis of that, this decree, have you approached the authority concerned for any partition and all? Have you approached? No.
No.
You have also not
No.
approached. Okay. Yes, so that much is your submission.
Yes. So here
Yes.
basically my lord have already done through my learned friend has here total land is a scheduled land. A scheduled land is and a scheduled land equal to B plus C. B is given to the defendant as per the plan. B is given to the plan defendant and C is given to the plaintiff.
As per the oral.
Yes, as per the plan. So in other words, the A scheduled land, they say they are entitled to get A scheduled land. And defendant are entitled to get B scheduled land. Now, that's their case. We say that A scheduled land, B scheduled land should be divided 50-50 because we are the brothers, own brothers. And C scheduled land should also be divided equally 50-50. Then problem is solved. Problem is solved. But here is a case where they are claiming A scheduled land, and they themselves has also stated that B scheduled land is almost more than the C scheduled land. So they are double. So they are very generous. The plaintiffs were very generous, but because they have given double the land of their share. And we say that, for example, just I am giving an example. That, for example, this high court, and behind the high court there is a land, there is a market area. And now the high court is the C scheduled land. And near the bank of the Brahmaputra, that is the B scheduled land. And that B scheduled land is given to me. A scheduled land is C scheduled land, my lord. They say that they are entitled.
And our only problem is this, that entire B and C schedule land should be vertically divided. Because C schedule land is a market area and three sides of the land is a roads are there. Three sides, here also road, here also road, here also road. And this is the land. And this is the highland, this is a market area where about 35 or 36 shops are also there. It's a total market area. And this market area he is now trying to occupy. My brother is trying to occupy. And he says then down the Mercy land, the down below watery land, and this land should be given to us. So ours is this that B schedule land and C schedule land, it is also belongs to our father. That is also belongs to our father. And we have inherited this property. There's no dispute, nothing of the sort. We say that B and C should be divided equally 50-50. That's the thing. And here in this case also, my lord will find that the suit was filed, and in response to suit we have appeared, we have filed our WS, and subsequently we have failed to appear. As a result of which suit was proceeded as party as against us. And that is the fault of the advocate because we don't know, my lord, how that was happened. No document, nothing of the sort from our side. We could not also cross-examine their witnesses. So this is how this suit was proceeded as party. And if that is taken into consideration, then the matter can be remanded, my lord, giving an opportunity us to produce our documents, our evidences, and also can cross-examine them. That is one aspect. And if my learned friend agrees to it, that yes, since there is an inherited property, both are brothers, B schedule land and schedule land should be divided 50-50. Then here also matter can be sorted out, and it can solve the pure and simple matter. And other things have been admitted by both sides. If my learned friend agrees, then
Another aspect, your friend has been, their counsel has been pointed out that though Schedule C property declaration was given in favor of the plaintiff for the respondent, but a preliminary decree is passed division of Schedule A property in two equal shares. So that is a bit confusing or bit.
Yes.
On one hand, C schedule property was given, declaration was given in favor of, so in otherwise, a preliminary decree was asked to drawn for the equal shares.
Equal.
For both. Okay. Yes. That's all.
My learned friend is asking me, Aru Kiba Aseni. I am saying, madam, why have you come so late? They have filed this suit. We have filed this suit at a time, and there is also no counterclaim from their side. So at best, I believe, my lord, this matter should be remanded back. And only thing, this time they should not commit the defaults which they committed, my lord. I can even take your lordship to the order. Not only when the case was declared ex parte, my lord, even before that they had defaulted and case was declared ex parte, suit was in ex parte even earlier. But then again that was restored. And thereafter again they committed the same thing. So repeated such actions lead one to, my lord, the suspicion that, my lord, there is some money, my lord, hidden agenda to delay the process. My lord. They will come back again to restore the case. In the meantime, they'll gain some time. All those things are there. So keeping that thing in mind, my lord, your lordship may remand the matter back. And asking them to, my lord, the trial court to expedite the matter. And direct the parties not to commit default, my lord.
Yes.
And to.
Yes.
Because this order, my lord, I have seen, my lord. On one hand, they have given us the C schedule. And on the other hand, my lord.
Yes.
Yes, my lord. there is
The
a
order now see
Well,
the preliminary decree is passed for division of C schedule, A schedule
ma'am,
land.
yes, ma'am.
A schedule land is obviously as submitted by the other council.
Otherwise, my lord, they have got 5 bighas and more, my lord. This is possibly in the mind of the father, my lord, who had divided it verbally, my lord.
There
Because
was
they
an
have
oral,
one
oral
brother given because of the land is on a highland. So, my lord, you take less and they have been given the cultivable land. So you get more because value difference is there, man. This thing has arisen because of the fact that there is a road constructed sometime back, man. When the road is constructed, there are shops coming up on both sides of the. That is the issue, man. And we cannot stop development, man. And it is between two brothers. Let the matter go back. Let them clarify. I think that will be better, my lord. Because if I take instruction again, the matter will take some more time and all that. So let it go back. And let there be a direction to expedite the proceedings of this. Because otherwise, this will be a problem. My lord. This A schedule land into 2 and then again saying that C schedule land
The
in.
main crux of the matter is that only.
Yes, ma'am.
The C schedule property otherwise is in favor, in your favor, and then
Yes.
again A schedule is 50-50.
Exactly, ma'am.
That may be a problem.
If the direction was for A schedule into, my lord, B and C, that direction is not there. Then again equal share.
Mm.
So there is a conflict.
Because B plus C is A.
B plus C is A. If the direction was for, my lord, demarcating the land into, okay, this B schedule land, this is yours, C schedule land, this is yours. It is not there.
It is not.
So that may create some problem. And between brothers, let them be at peace.
Continue করে দিন।
There is only one issue, my lord. My lord, prior to making this suit, my lord, declared as expertise, my lord, we had given the affidavits on affidavit. The plaintiff side.
Yes. That
Now
was
they
accepted.
now they were not there no except and there was no cross examination. If the matter gets back, my lord. If the,
Obviously, they will get that opportunity of cross examination, but
now in that
it
case,
will
my
be-
lord,
it will be- in that case, yes, it is.
some of them have, some of them are no more.
Oh.
Some of them. Yes, ma'am. For example, my lord,
Now,
one.
some PWs have already expired.
Yes, ma'am. Abdul Rahim dead. Then one Hazrat Ali since dead. So your lordship, so therefore, my lord, your lordship has to give us a grant of the liberty, bring other witnesses which they can process them.
That's so. But in that case, what will happen? That the PWs which have already been examined may be cross-examined by those are alive.
Yes,
Those are
yes,
still
yes.
alive.
Those who are alive.
Those who are alive.
Those who are definitely.
And the persons who have already got expiry, you may get an opportunity for because they will also get an opportunity for adducing their
Yes, but
evidence.
if we bring in additional witnesses, they will get the opportunity.
So in that case, issues are not being framed, I think. Oh, issues
Issues
are
are
already
framed.
been
Issues are being framed.
Issues are
Thereafter, evidence.
that case, so the matter will be remanded from the will be started from the
Yes,
hearing stage.
yes.
Otherwise, it will again create some problem.
Well,
Some PWs which have already been not examine your affidavit has already been given. They may get an opportunity for cross-examining those, and you will be at liberty.
My lord,
that
ideal
that's what-
situation, I do not know. Ideal situation would have been to, for the trial judge to, my lord, clarify her judgment, a clarificatory judgment.
Yes, because
Whether-
judgment is not verified.
Yes, whether that will be possible or not, I don't know.
Yes, because
It
it will
is
create
possible and it
problem,
is
some
done.
problem, because decree which has already been passed may not be an executable decree
Yes,
properly.
yes.
That is the issue.
And there was an Amin Commission's report, my lord, that I have a copy. That was,
You are already annexed here, or yes, in that.
yes, my lord.
So
This is
proceed.
the Amin Commission's report, my lord. This circle officer of Dolgaon Revenue Circle was constituted as the Amin Commissioner and who had prepared this report on 11/12/70.
11, 12,
70.
17. 11, 12, 17, which the order was passed on 20, 12, 16.
Yes, madam. This
The
was on
report
11/12/70.
On the basis of that report, whether anything has been done on the basis of that.
11/12/17. This is the later latest one.
So after the preliminary decree.
Yes,
that-
madam. After that.
After that. So now what then? It is already partitioned or what? Honor.
This was done on the basis of the, my lord, that preliminary decree. by the-
It's so much. So A schedule contains 7 bigha, 7 bighas, 3 kathas, 18 lessons.
Yes.
Uh,
That is a cumulative figure. B plus
now yes, B plus C.
A, B plus C.
That is A schedule land.
A schedule.
মাটিত দিয়া ভাগ বতৰা কৰি সমানে সমানে কৰি দিয়া প্ৰতিটো ভাগৰে তিনি বিঘা। এই মুঠ 2 বিঘা। That means it is already definitely. Now did ক and খ body Ali A scheduler mode 7 bigha, B and C they have here, B and C is there. It is already partition or what's it? B and C, B and C. Because B schedule is also partitioned, I think, and C schedule is also partitioned. See? If it is there already, then what purpose?
Well, may I just read, ma'am?
Yes.
উপৰোক্ত বিষয়ত সন্মান সহকাৰে জনাও যে দেৱানী ন্যায়াধীশৰ নিৰ্দেশ মৰ্মে শ্যামাবাৰী মৌজাৰ ধনশ্ৰীকাৰ গাঁৱৰ 6 ম্যাদী পটাৰ 161, 162, 186, 187, 190 আৰু 191 দাগে মুঠ 7 বিঘা 3 কঠা 18 লেচা মাটি সমানে দুভাগত বিভক্ত কৰি প্ৰতিটো দাগ ভাগ বিঘা 4 কঠা 9 লেচা মাটি বাটোৱাৰা কৰি দিয়া হয়।
হয়। তাৰপিছত
ভূমি লক্ষ্য নথি মতে দেখা যায় যে চামবাৰী মৌজাৰ ধনশ্ৰীকাহ গাঁৱৰ 63 নং ম্যাদী পটাৰ 161, 162, 186, 187 আৰু 191 দাগে মুঠ 7 বিঘা 3 কঠা 18 লেচা মাটিত পটাদাৰ নিজামুল হক আৰু বজলুৰ ৰহমান উভয়ৰে পিতা আবেদ আলীৰ নামত নামজাৰি চলি আছে। মহামান্য দেৱানী ন্যায়াধীশৰ নিৰ্দেশ মৰ্মে 3/11/17 তাৰিখে চামাবাৰী মৌজাৰ ধনশ্ৰীকাৰ গাঁৱত উপস্থিত হৈ ম্যাদী পটা 161, 162, 186, 187, 190, 191 দাগে মুঠ 7 বিঘা 3 কঠা 18 লেচা মাটি তলত দিয়া ধৰণে বাটোৱাৰা কৰি সমানে কৰি দিয়া, য'ত প্ৰতিটো ভাগৰে মাটি 3 বিঘা 4 কঠা 9 লেচা। বাদী ফজলুৰ ৰহমান পিতা আবেদ আলীৰ ক্ষেত্ৰত এই চিডুলৰ মুঠ 7 বিঘা 3 কঠা 18 লেচাৰ পৰা ৰোমান 1 চি চিডুলৰ 186, 187, 190, 191 দাগে মুঠ 2 বিঘা 2 কঠা 17 লেচা মাটি।
That means C বিঘাত otherwise কিমান আছে? What was the মাটি? That is two
She
kotha.
was two bigha and
That means
Not-
that is already given.
two bigha, two kotha asile, C schedule.
So what amount?
And then out of that,
Ah.
C schedule 186 এসপ্তাহে 190 191 টাকে মুঠ 2 বিঘা 2 কঠা 17 লেচা মাটি আৰু বি শিডুলৰ 161 আৰু 162 দাগৰ অংশ এবিঘা 1 কঠা 12 লেচা মাটি 161 নং দাগে 1 কঠা 15 লেচা 162 কঠা 162 দাগে এইটো this is not there in the this is has not come on this page 17 লেচা মুঠ এবিঘা 1 কঠা 12 লেচা সৰ্বমুঠ 3 বিঘা 4 কঠা 9 লেচা মাটি বাদি বাটুৱৰা কৰি দিয়া হয়
That means she schedule entered she schedule was given to play
yes
as per that partition.
now আকৌ বিবাদী নিজামুল হক পিতা আবেদালিৰ ক্ষেত্ৰত বি শিডুলৰ 61 আৰু 162 দাগৰ অংশ 3 বিঘা 4 কঠা মাটি বাটুৱৰা কৰি দিয়া হয় এইটো 5 বিঘা ন 161 দাগে 4 কঠা 14 লেচা আৰু 162 দাগে 2 বিঘা 4 কঠা 15 লেচা মুঠ 3 বিঘা 4 কঠা 7 লেচা পকা থাকে উক্ত পটৰ 186 188 নং দাগে এবিঘা 1 কঠা 1 লেচা আৰু 161 আৰু 162 দাগৰ অংশ এবিঘা 1 লেচা মাটি বাদী ফজলুৰ ৰহমান পিতা আবেদ আলীৰ দখলত নাই or some land I mean that possibly they had said in their written statement is in there, that is not in their possession গতিকে মহোদয়ৰ বিহিত ব্যৱস্থাৰ প্ৰতিবেদন দিয়া হ'ল it was filed before the court below I do not know if it is there in the lower court record.
C schedule is given. C schedule is totally given, and some of the land from the B schedule land is also given.
The B schedule land is not given.
More than their prayer.
B schedule land is not given to me.
Given it.
Badi.
C schedule is given to you, and apart from then from B schedule, most probably some of the portion of land is given to you.
Yes. No, what they have said is প্ৰকাশ থাকে যে উক্ত পটাৰ 186 187 নং দাগে এবিঘা 1 কঠা 1 লেচা আৰু 161 162 দাগৰ অংশ এবিঘা ইমান লেচা মাটি বাদী ফজলুৰ ৰহমান পিতা আবেদ আলীৰ দখলত নাই they said this land is not in my possession that's what they
That
said
is there. That is
Yes.
not in your position. But if
no.
you see the upper part, here there it is in the C schedule land which contains 2 bighas, some kathas is
Yes.
given to totally given to you. C
Yes.
bighas, entire C bighas is given to you. And apart from that, from the B schedule, most probably some portion is given to you.
Yes.
So as a whole, 3 bighas, something was given to you. Both from entire C schedule and then from again from B schedule.
B schedule.
Some portion from
Yes.
B schedule. That is
So that is more than their
but
prayer
I'm just
expense.
asking on the basis of that report of the circle officer, whether any mutation was there or any
yes
No, no.
mutation is I think
that-
they have
mutation was there.
mentioned is
In
there.
that case, it could be again.
Mutation is admitted, but except this last, I do not know, 186, 187. They said the plaintiff has no, it is not in your, and there is also another issue. There is a sister named Rukia Begum. Now, she had materialized, my lord. I have the order sheet with me. Towards the end, when the decree was made, my lord.
Can
She
she
had,
appear?
she claimed that some land in DAG 161 and 162.
She was not more. She was
She was
not made
not
party.
made a party.
She was not even made party there.
But she has the right.
Yes,
Yes.
That's why my lord, base course will be my lord. Let the matter go back, my lord. Let the entire aspect of the matter can be taken into consideration by the trial.
But I'm
court, my lord.
asking whether mutation was there also.
Mutation is there, man.
No. On the basis of that partition,
Yes.
on that basis of that partition, whether mutation is
No,
no, not
I
yet.
don't think. No, that is the earlier position. This is not given effect. I think.
Not given effect.
It is not given effect because it has
Because
come
in the
slightly.
meantime, my lord, the
But that can be.
appeal has come, my lord.
Achha.
And because the pendency of the appeal.
Because the appeal was filed in the year 2017 and this is the 2017 December. So it was not given.
So where from you are saying that the sister has also appeared outside?
No, from the, I can show. It is in the order sheet.
She also filed any application
She filed an application
before the trial court?
Yes, ma'am.
Or
before the trial court.
But why she is not here at the time of passing the decree?
My lord, actually, these sisters have been provided for, my lord. They are married off. They have been provided for land elsewhere. This is possibly a frame up. They are possibly a frame up. I am not saying anything because this is between two brothers.
As per my lord, the plain, my lord, so many brothers and sisters are there. And as
The
per the-
brothers, there are two brothers, sisters, I think 5 or 6 sisters. are
and
there.
all
They have
sisters
been
or
given
brothers,
land.
my lord, they have given their land.
Even
And they are
Ruki-
not coming before the
but,
court, my lord.
but this
Now it is only because of these two brothers, not others. my
this Rukia, my lord.
But Rukia, when she filed
Yeah,
the
Rukia has been made a frame up, my lord. She has been asked by my lord. Let us not say, my lord. Let this matter go down, my lord.
No, where from we are saying that.
My lord,
Rukia
I just like to show the date of the order, my lord. It is there. Yeah, taken. Yes, my lord. 15, 11, 17.
15, 11, 17.
That is one.
That is after the decree.
No,
After the
after
judgment.
after the
Because judgment is of 2012, 2016.
exactly. That is one one order, my lord. 15, 11, 17. But,
But
is,
what
the-
was
is
the
the order
order?
sheet before your lordship, my lord?
No, what was the order? 15, 11, 17?
Actually, this would be 16, 11, 17. It's a continued order. It written 16, 11. Now here they have written 15.
Anyway, 15 or 16, 11.
But also
But
seen
there was
20
17.
yes, 17. Also seen petition number 2549/17 filed by the petitioner Rukia Begum, stating that she is the elder sister of both the plaintiff and the defendant. She has also stated that she was kept in dark about the instant suit and the decree has been obtained fraudulently. When the circle officer visited the suit land, then only she came to know about the said decree. Since for shortage of time, she could not obtain the relevant documents, she could not file objection today and hence prays for time for procuring the land documents and filing objection. Considering the ground cited, the petitioner is allowed time for filing objection. Execution proceeding be stayed till filing of objection. 1612 then again.
Execution is stayed.
Yeah, till 1612. By 1612/17, the Amin Commissioner's report had come.
It is in the execution.
Execution. That Amin Commissioner, I have just shown my lord. Report of the Amin Commission. This has come.
That petition was on the
Uh,
petition is not still.
My lord, on 1612/17 also, fixing, my lord, last line, fixing 03012018 for filing objection by Mosammat Rukia Begum. Then,
Fixing?
For filing objection by Mosammat Rukia Begum.
No, which date fixing?
3118.
3118.
Yes, then 3118, my lord, another order is there. Both sides present, Mosammat Rukia Begum has filed objections.
So all these petitions are being filed at the stage of execution.
Execution.
She didn't know what happened, my lord.
There.
After the Amin Commissioner was appointed and he had gone there for demarcation or partition, my lord. Then that is her case. Then only I came to know. So therefore, I need some time to file my objection and all. And both sides present, Mosammat Rukia Begum has filed objection.
If that is so,
She filed objection.
If that is so, my lord. If that is so, my lord.
Okay, objection.
Let other sisters also come. No, there is no problem. Let the matter go back. Let the matter go back. Well, if anybody is agree, they will get this chance.
1 bigha, 1 kata, 12 acres under DAG number.
Because these are all in the execution.
Can you file those the orders before us, because we have called only the suit,
My lord.
case record of the title suit only. There is no execution case record.
Okay, I think I can give it.
You can just file. I'll keep a note there only. That much only.
I'll make a photocopy and I'll give it to him.
Yeah, you can give it. Yes, both the circle officers report.
My lord, this
as well as-
order sheet is there. I can give.
And an execution case number. What was the execution case number?
Well, possibly no case number was, my lord.
Oh, here only.
Yeah, yes, my lord. Because the record is same. because it was a preliminary decree.
Hmm.
So after passing the preliminary decree, my lord, they appointed
Appointed
the
him.
circle officer as.
Yes, yes, for,
So they continued that as a.
yes, in that case.
Well, I'll submit a copy of this.
Because these orders may not be, I don't know. We have to check it because this RFA is of 2017. Some of the orders have been continued till 2018 also.
Maybe.
As you have
Oh yes,
said,
3118 one is there.
2018 is there.
No, even thereafter, madam. 2 to 18.
Then there are
Plaintiff present, learned advocate for Srimati Rukia Begum is present. Presiding officer is under order of transfer.
So it seems that the execution proceeding is still pending.
Right.
So even at this, after filing of the appeal, the execution is still pending before the.
Yes, because the other records have been brought here. Some records have been shows the key record police, lower court record key police.
Yes.
LCR. The causeless shows that LCR is.
Ah, no, LCA is there. Outer sheet.
Execution case. Execution case.
That proceeding is, my lord, going on.
Execution case.
Yes, yes. These are here also. Here also.
Record.
It is there.
It is available
Yes.
up to 2004, 2018, then
Possibly that proceeding
21,
is.
because stay was not there, I think, na?
Still, the record is here. I think.
Record was called.
already here.
Record was called.
No, record was.
By the time
or
the
at the
record
time
was
of
sent.
filing your RFA, there is no stay, I think.
State was in.
Otherwise, it is proceeding.
That proceeding is going on till the records were sent here.
Yes, that's what I'm saying.
Security.
Okay, we'll pass the
But the direction, my lord, to expedite the proceedings, but that is adjournment. Let all for which I seek some time. And they grant us some time. It is amongst the same family. More or less, they will settle or try to settle my. But subject to my learned friend's instruction. So let it come on a day.
In fact, my lord, after getting information, my lord, my learned friend, I talked to my client. My client says, my lord, there is no possibility, my lord. Is compromise the same, and depending on the. My
No,
lord,
see, now the question
and
is that
compromise can be taken place at any time, and even the matter is remanded back, my lord. Compromise can be taken place if it is compromised.
If it is can be compromised here, my lord, why should it be?
take deliver. That is the question. Now, in fact, you have talked to your client.
I talk to my client.
So see, what I'm saying, what I'm thinking about, suppose there is an order. Order is a bit confusing. I have already said it, that decree is there and the other one. So now if you go by strictly by the decree, suppose, in that case, schedule A land should be equally divided 50-50. That
Exactly.
means from the C schedule land also 50-50 and the B schedule land also 50. It
Right.
says so,
Right.
otherwise. But what the circle officer, report of the circle officer says that C schedule is already given to so-and-so as per the order, decree, whatever.
Right.
And then from the B schedule, so low-lying area is exclusively given to you. So in that context, suppose if there is any compromise from the other side, then most probably you will be in the beneficial position. I think.
More benefits.
More benefits will be there. Suppose if in that manner, suppose if as per the decree, if it is divided.
My lord, I appreciate. I appreciate to your lordship, my lord. And only my lord, my learned friend may take time, my lord. I have already taken time. In the meantime, my lord, there may be a compromise also, my lord.
Yes.
No issue. But your lordship will keep it part heard, my lord.
Part heard I can keep. One part heard is already
Because since your lordship is hard the matter, my lord.
I don't.
I don't have any objection.
Okay, it should be remain part heard.
Yes.
My lord.
Item number 11.
If your lordship has
Mr.
already.
M.H. Chaudhary, Dilane, Senior, assisted by Mr. M.A. Chaudhary, the counsel for the appellant, and also heard Mr. B.D. Gupswamy, Dilane counsel, representing the respondent side. The matter is part heard, but during the argument, it is submitted by Mr. Goswami that there may be some possibility of compromise of this case, and accordingly it is sought some more time for further hearing. In view of it, let the matter be listed. How many weeks you need? 4 weeks? 8
Sometime in,
weeks?
yes, February.
May be listed in the second week of date need of second week of February. Second week of February as an date to be fixed by the registry. It's a partner project, partner. So we are listing it on second week of February, probability of 19th February.
So Lordship
So
is
just-
keeping it part of.
Yes, I have come to know the entity.
Let us make an effort.
Yes, let.
Much of
Sorry, Your Lordship. Not attend earlier.
Just brief the gist of the thing, otherwise we have heard. Your apparent side we have heard, there's the concurrent findings. I have always noted down.
The-
So just give me the brief.
The facts in earlier
Facts in
occasion.
nutshell,
Your
and
Lordship,
give me the
the
brief.
nutshell.
Otherwise, I have already noted down. More or less, your submission has already been noted down.
Regarding the two substantive question of law was there, the Lordship. Number one was that whether the finding of both the courts below that the registered sale deed, Exhibit 5, was null and void is correct after holding that the respondent's plaintiff be a tenant under Assam Temporary Settled Areas Tenancy Act. So, Your Lordship, for this substantive question of law,
Otherwise, it was a concurrent finding.
definitely
Concurrent
concurrent finding, Your Lordship. And on 14/8/25, this honorable court, while hearing the matter, a second substantive question of law is framed. The second substantive question of law is whether the judgment of the learned trial court as well as the first appellate court suffers from perversity on account of non-consideration of evidence of DW1, DW2, DW3 and 4 in deciding the issue at the point of determination formulated at the time of hearing. So, in both the judgments, there is no whisper about the evidence of any of the witnesses. One, DW, the appellant here was the defendants, and they had adduced 4 witnesses.
You are the defendant.
Yes. DW 1, 2, and 3 and 4, there is no whisper about the evidence of any of the witnesses in both the trial court and the, Your Lordship, the first appellate court, for which this honorable court satisfied that there is a substantive question of all law regarding perversity for non-consideration of the evidence. Without considering, even without discussing
But
the
your evidence was only on the oral evidence, or documentary was also there?
documentary
Documentary
evidence
evidence was also.
yes, oral and documentary evidence also. And the law regarding the first substantive question of law, Your Lordship, the plaintiff's prayer, I will go to only for the plaintiff's prayer, Your Lordship, prayer portion, that is that is page number 54 of the memo of appeal.
Page number
54 is the memo of appeal, Your Lordship. Yeah, the prayer 59. What is the prayer of the
Prayer?
plaintiff? The prayer of the plaintiff for declaration of plaintiff's tenancy right in the suit land described in the schedule below. So this is not a case for declaration of right, title, and interest, Your Lordship. The plaintiff's case is not that he should be declared as a title holder of the land. His prayer only to the extent of tenant. He is a tenant of the one of the defendant number 4's father and his brother. It is his case. Defendant number 4, from which the defendant number 1, 2, and 3 purchased the suit land. Lordship, we are the purchaser of the suit land from defendant number 4, Vimalendu Das. And Bimalendu Das is one of the landlord of the plaintiff. It is most important, your lordship. This point, and that was the prayer one. That is, his prayer was not to declare the right title and interest. He is declaring only the tenancy right, and that right is declared. And the substantive question of law is related to this issue, that when his right as a tenant is declared, whether the sale deed executed by the landlord is to be declared null and void. Because in one of the prayer is to declare my purchase deed as null and void. The second prayer is confirmation of plaintiff possession in the suit land described in the title below. So for the second prayer, the evidence should be discussed. The oral evidence will suffice, substantiate the possessor who was in possession. But none of the witnesses is discussed regarding this prayer. Permanent injunction restraining the principal defendants, disposing plaintiff for adjudging the said registered copula. D. D is the prayer D is for declaring the principal defendant 4 in favor of the Omar Chandra Das, principal defendant, suit land number so and so. This is deed number 3642. That is my deed. I am a title holder by a registered deed, a registered sale deed executed by the landlord of the plaintiff. That is admitted. Ordering the said registered copula number so and so delivered to be cancelled, and it is accordingly cancelled. So, regarding the first substantive question of law, since to decide this question, none of the evidence is
That the landlord is also made a party here.
yes.
He is defendant number 4.
Yes. Defendant number 4. He also submitted his written statement. So, this substantive question of law, and regarding this tenancy right, your lordship, the document adduced by the plaintiff before the learned trial court is the Khotian. On the basis of Khotian, Exhibit 1, your lordship, if your lordship go to the LCR or in other day it is gone. In the LCR, in the first column, the name of the plaintiff is there as name of the father's name of the resident of the tenant. So, on the basis of this Khotian, and in the Khotian, the name of the landlord is there. Landlord, particulars of the Pattadar. Your lordship may peruse the Exhibit 1, your lordship. Because on the basis of only this document, the
Exhibit 1, you are saying?
Exhibit 1 of the plaintiff.
Yes. This is the Khotian.
Yes, this is the Khotian, and Khotian means, your lordship, the record of rights. Khotian means record of rights, and it is a established position of law that Khotian is not a title document. Khotian is a proof of is a document where the details of the land is there, your lordship, name of the tenant, name of the landlord. In the first column, the name of the tenant is the plaintiff, Munindra Chandra Das, and column number 12 is Robindra Chandra Das and 5 others. Robindra Chandra Das and 5 others are the landlords, and among these 5 others, one is the defendant number 4, the Bimalendu Das. And this Bimalendu Das included in these 5 pattadars is there in the evidence of PW1. So now to prove that one of the pattas is Bimalendu Das, my vendor. So for proving this, there should be discussion of the evidence of PW1. PW1 stated this fact in his cross-examination, but it is not discussed. PW1 stated in his cross-examination, let's see. So may I draw your lordship's attention to the cross-examination of PW1.
PW1 was enclosed with appeal memo, your lordship, page 71.
PW1 is Murindra. Page 71.
71.
Yes. I'll go by this one. Yes. What do you want to submit from here? Please. Cross.
Yes, cross part, chief. The handwritings are very illegible. Page number 75 here. Page number 75, first, second, third paragraph. Third paragraph, except exhibit 2. Page number 70. The lordship got it.
Exhibit 2.
Exhibit 2. I have no other Farox. Farox means revenue receipt here. I have no other Farox.
Except exhibit 2, I have no other.
No other Farox. Only one.
Farox means?
Farox means revenue receipt. He had payment rent to the landlord. The payment of rent receipt, payment of rent receipt, 75. So next he said Ronendra Das. It is Ronendra Das, Bimalendu Das. Bimalendu Das is the defendant number 4, my vendor. Bimalendu Das, Nivedita Das, Nivedita Bishas, Robindra Das, and Pratibha Das are the 5 pattadas. They are in the exhibit 1. There is one Robindra Chandra Das and 5 others. So Robindra Das expired, and the remaining 5 is there. He mentioned the name of remaining 5 persons. These 5 persons included my vendor also. So in the exhibit, the landlord Bimalendu Das is there as a landlord, as a pattadar. He admitted. So pattadar means a title holder, your lordship. So my vendor is one of the title holder. So there is admitted that my vendor is a title holder and he is the owner of the land, and the plaintiff is only a tenant. So the subsection of law is that the landlord sold the property to the defendant hearing, and this sale deed is declared null and void, and it is registered sale deed is cancelled on the basis of tenancy right of the plaintiff. Now, regarding this entry, regarding this mutation entry, that it does not create or extinguish the title of immovable property. This is the Ishwar Das 2001 SCC 434. Para 11, may I read? There are two situations in which interference with findings of fact is permissible. The first one is when material or relevant evidence is not considered, which I considered would have led to an opposite conclusion. This principle has been laid in a series of judgments of this court in relation to section 100 so and so. The court, the first appeal is due to under examine the entire relevant evidence on record, and it refuses to consider important evidence having direct bearing on the disputed issue, and the error which arises is of magnitude that it gives birth to a substantial question of law. In that case, an admission of the defendant tenant in the reply notice in regard to plaintiff's title and the description of the plaintiff owner of the property signed by the defendant were not considered by the first appellate court, while holding that the plaintiff had not proved his title. The High Court interfered with the finding on the ground of non-consideration of the vital evidence, and this court affirmed the said decision that was upheld in Jogesh so and so. Where findings by the court of facts is vitiated by non-consideration of relevant evidence or by essentially erroneous approach of the matter, the High Court is not precluded from recording proper findings. Again, in so and so was held that where certain vital documents are decided for deciding question of possession were ignored, such as compromise and order so and so revenue court. Next, my lord, paragraph number 12, Mary. The second situation in which interference with the findings of fact is permissible is where a finding has been arrived at by the appellate court by placing reliance on inadmissible evidence, which, if it was omitted, an opposite conclusion was possible. In this case, only on the basis of this exhibit 1, this Khotian, the plaintiff is declared, his title is declared. It was held that High Court was right in interfering with the second appeal, where the lower appellate court relied upon an admission of a third party treating as binding on the defendant. The admission was inadmissible as against the defendant. This was also a second appeal of 1981. In either of the above situation, a substantial question of law. So this is regarding perversity, non-consideration of evidence. Now, Your Lordship, Honorable Guwahati High Court's 2007-4 GLR 610, Doyal Hari Pal and others, one judgment. Yeah. Here, paragraph number 9, Your Lordship. Paragraph number 9, Your Lordship, the alleged admission of the plaintiffs on which heavy reliance was put by the learned trial court is in fact a perverse finding, inasmuch as Petitioner 1 immediately after stating that defendant vacated the suite houses in the year 69 has further stated that in the year 72, in the month of March, the defendant again returned back to the suite premise, and this vital aspect was left out of the consideration by the learned trial court. And this statement of the plaintiff is of no consequence with the statement made in the plaint inasmuch as the claim of the plaintiff is that the suit premise were taken into rent in the month of March 1972. The other consideration of the learned trial court was that the order of the revenue board set aside the mutation order. Now this is the relevant. The order of mutation is only to facilitate the payment of land revenue. Revenue court is not entitled to decide title in respect of landed property, which is a subject matter civil court. The order of mutation does not confer. The order of mutation does not confer any title which has been categorically held by the apex court in the case of so and so. So the this Kotian is a record of right. Record of right, that is, it proves that he is a tenant of the landlord and nothing else. And it does not confer title. The Honorable Dishonorable Court held. Now, regarding the non-consideration of material evidence, Your Lordship may I refer to Supreme Court judgment 2025 AIRSC Jyoti Sharma. Jyoti Sharma's case, paragraph number 14. In that case, that was also a concurrent finding of the trial court, first appellate court, and even the high court. Concurrent judgments have been set aside, Lordship. On the above reasoning, we find the concurrent decision of all the three courts who have not considered the material evidence and entered into finding in a perverse manner based on mere surmises and conjecture.
Which para you're relying?
Para 14, 1-4. Due to non-consideration of material evidence, the Honorable Apex Court set aside the concurring judgments of all the three courts from trial court to high court, Your Lordship. On the above reasoning, we find the concurring decision of all the three courts of have not considered the material evidence and entered into finding in a perverse manner based on mere surmises and conjecture. We set aside the order below and decree the suit directing the recovery of the rent area from so and so till handing over the possession and order of eviction, default of payment of the rent. So, my lord, the first substantial question of law, this honorable court framed regarding the declaration of tenancy right. So tenancy right does not create or extinguish title. So, and the prayer of the plaintiff is only to declare him as a tenant. He is not claiming the right title interest of the suit land. But without establishing his right title and interest, my sale deed, my registered sale deed, which is a title document, cannot be set aside, Your Lordship. And regarding these findings, not a single evidence has been considered, Your Lordship, for which Your Lordship, may I draw Your Lordship's attention to the trial court judgment for a page number 30. Page number 30, Your Lordship. Issue number, the important issues, page number 34. Page number 34, 4, 5, and 6. Issues, Your Lordship. And before going to the issues, may I draw your lordship's attention to page number 44-0, where the documents and witnesses is appendix is there. Page number 40 before going to the page number 34. Page number 40, your lordship, plaintiffs, witnesses 1, 2, and 3. PW 1, 2, and 3, and documents 1 to 7. Final Khotian is exhibit 1. Exhibit 2 is the Farag is the revenue payment receipt. Only one revenue payment receipt he had exhibited, and one copy of Azahar. This is a Azahar he had taken a plea that all other revenue receipt has been taken by the dacoits. So this Azahar is not proved. It is also in the evidence is there. It is not proved this Azahar that his all other revenue receipt has been stolen by the dacoits. 4 is the map. 5 is the certificate copy of deed number so and so. That is my purchase deed, your lordship. Exhibit 5. Exhibit 6 is the certified copy judgment TS number 59 of 4. It is another judgment, another matter. 7, exhibit 7, certified copy of decree. List of defendants' witness. This is important, your lordship. Defendants adduced 4 witnesses. DW1 is the defendant number 1, himself. DW2, Gurupada Das. DW3, Manoid Mia and Satyendra Das. So these are the persons who have been examined. And in these witnesses, the regarding the prayer, regarding the possession, these oral witnesses to prove who is in possession. In fact, the appellants herein are in possession before the date of purchase, from before the date of purchase. And if it is even held from the date of purchase also, it will be proved by the witnesses, your lordship, regarding the possession. But the learned trial court, now I will come to page number 34. Issue number 4, whether the plaintiff have tenancy right in the suite land. So tenancy right is issue number 4. Whether 5, whether the registered Kabula is illegal and void. And number 6, whether the plaintiff is entitled for any relief as prayed for. Now, your lordship, may I go to the issue number 3? Issue number 4. Issue number 4 regarding the tenancy right. Issue number 4, may I read whether he has discussed the learned trial could discuss the evidences of the witnesses here. This issue relates to right of the plaintiffs as tenant over the suit land, and therefore the burden lies upon the shoulder of the plaintiff to prove this issue. The plaintiff side adduced 3 witnesses and 7 numbers of documents. The plaintiff is examined as PW1, and in support of his claim, he submitted the evidences of on affidavit as a form of oral evidence. He submitted that he took tenancy settlement of the suit land and other land from Rakesh Chandra Das and Rabindra Chandra Das. Rakesh Chandra Das is the father of the my vendor. Rakesh Chandra Das and Rabindra Chandra Das in 1368 BS, and in the same 1368 corresponds to 1961 year. And in the same year, the Pattadar recognized his tenancy settlement of the entire land he had purchased and issued the final Khotian number 468 granting to rent received so and so. So, your lordship, I will refer one. I will, after reading this, I will refer to the regarding the ownership, acquiring of ownership right. Assam Temporary Settled Areas Tenancy Act 1971 provision 23 provides how a tenant acquires ownership right. A tenant can acquire ownership right, but in this case, the plaintiff did not prove that as per this act, he has acquired the ownership right. If it was proved that he has proved his, as per law, he has acquired his ownership right, then the learned trial court and the appellate court is right in deciding this issue that he is the owner, and the landlord has no right to transfer the land. That is not the case of the plaintiff. that he has acquired the ownership as per the Assam Temporary Residence Act. This is one of the important aspects, Your Lordship may kindly note that in this point, Your Lordship. So after completing the reading, he submitted the original final Kotian, which is proved as Exhibit 1, and also submitted the original rent receipt 27/12/77, which is proved as Exhibit 2. The Exhibit 2 was issued by the Pattadar who signed therein in his presence. So only these two documents, based on only two documents, my registered sale deed has been declared as Nazal bond. Number one is his Kotian, which proves that he is only a tenant, not the landlord. And number two is that one revenue payment receipt, rent payment receipt, he has paid to the landlord, only one receipt. Only these two documents, my sale deed is cancelled. Submitted Exhibit 2. The Exhibit 2 was issued by the Pattadar who signed therein in his presence. He proved the signature. Pattadar is in the Exhibit 2 is my vendor's father, Rakesh Chandra Das. He proved the signature of the Pattadar of late Rakesh Das by Exhibit 2.1. The plaintiff PW1 also submitted that the Exhibit number 1 was finally published in 75 with the knowledge of all concerned, including the defendant, and he is in the possession of the suit land along with the other land. So this is the possession, this finding, Your Lordship, is a perverse finding regarding possession. This is with the all concerned, including the defendant, and he is in the possession of the suit land. Because without discussing the oral evidence of the witnesses, how the trial court came to this finding, Your Lordship, that he is in possession. On the perusal of both the documents, it is found that Exhibit 1 is the final Kotian issued in the name of plaintiff as tenant by the Pattadar Sri Robindra Chandra Das and 5 others. The suite land bearing DAG number 1097, measuring about 1 biga, 14 kata, 4 chotak, is found included in the said Kotian. On perusal of Exhibit 2, it is seen that said Exhibit 2 is also the original receipt being issued by the Pattadar Rakesh Das 27/12/77. On the other hand, to deny the case of the plaintiff, the defendants in their evidence submitted that the suit land is exclusively belong to the father of the defendant number 4 by way of periodic Khiraz Patta. So the defendant has at least 4 witnesses, but London trial court in a summary manner, he sum up the case of the defendants like that. In their evidence submitted that the suit land is exclusively belong to father of the defendant number 4 by way of periodic Khiraz Patta number 1 of the so and so, and after the death of his father, he became the owner of the suit land. The defendant Sri Omoresh Das, page 36. The defendant Sri Omoresh Das also denied that late Robindra Das was the Pattadar of the said suit, but the name of the plaintiff was wrongly recorded in the Exhibit 1. On bare perusal of Exhibit 1, it is seen that name of Robindra Das was entered into the said final Kotian as Pattadar along with 5 others. So the plaintiff's claim is he is a tenant of Robindra Das, not other Pattadar. Hence, the contention raised by the defendant number 1 to the fact that Robindra Chandra Das was not the Pattadar of Kotian 468 cannot be accepted. In regard to wrong entry of the name of the plaintiff in Exhibit 1, that is Kotian number 468, no cogent evidence has been cited by the defendant number side. It is right that the Kotian was not challenged. The Kotian was published is not challenged, it is admitted. But the Kotian, the case of the defendant is that the Kotian is not a proof of title. However, the defendant side filed a Xerox copy of the periodic Khiraz Patta number 1 issued in favor of his father, late Rakesh Chandra Das, and some of the rent receipts issued by the Rakesh Chandra Das, but has not been examined with the original. Being the mere Xerox copy, these documents carried no evidentiary value at all. The defendants had submitted the Xerox copies of the rent, Lordship. So it is not the settled position of law that the plaintiff's title can be declared on the weakness of the defendant. defendant could not prove their, this is the proof of a tenancy, that they are also tenant of the landlords. They could not prove their tenancy, but their ownership is proved by the registered sale deed. But the learned trial court mostly relied on these facts, that the defendants could not prove that they are the tenants of the landlords. They have submitted Xerox copies of the revenue receipt, and it is a settled position of law that it is the plaintiff, it is the burden on the plaintiff who has to prove his case. The plaintiff cannot depend on the plaintiff case cannot be decreed on the weakness of the defendants. So Xerox copies as such, the documents of the plaintiffs have high evidentiary value with respect to the documents submitted by the defendants. Defendants
You could not file any, so all are Xerox.
Xerox, yes. All are Xerox, but my case is that I am the registered sale deed. I am the purchaser. I am the purchaser, registered sale deed by the landlord.
Yes.
This was filed to prove that I was also the tenant of the landlord. If I fail to prove that I was also the tenant of the, that will not affect my case, because my case is that I am the registered purchaser. I have purchased the land from the landlord by a registered deed. That is my case. So this also submitted that if it could be proved by original sale deed, that one of the aspect would be that I was also in possession as a tenant before my purchase. If I could submit the original land receipt, then that was a proof of my possession before my purchase. But my possession is proved from the date of the purchase deed, sale deed. In the sale deed, it is mentioned that I have been handed over the possession on the date of execution of the sale deed, and that is proved by the witnesses. But unfortunately, the evidence of the witnesses has not been discussed. None of the evidences has been discussed. I also perused the scheduled and boundary submitted by the defendant in case of denial, the schedule and boundary of the plaintiff, and found that both the schedule and the boundary are same without having any contradiction. In view of the above discussion and reasoning, it appears that the plaintiff was the tenant under the Patadar late Robindra Chandra Das and others, and his name was rightly included in the final quotidian. So the trial court held that he is a tenant. He is a tenant. Accordingly, this issue is decided in favor of so the prayer number 1 is declared. Now, prayer number 5 regarding my sale deed. Page number 38. The next issue, whether my sale deed is valid or not. Page number 38, this issue relates to whether the Kapola deed number 3042, that is sale deed 2726 executed by one Bimalendu Das in favor of the defendant. Bimalendu Das is one of the patta that I have earlier noted. Sri Omoresh Das, valid or void. To establish this issue in favor, the plaintiff submitted Exhibit 1, Exhibit 2, and Exhibit 5. In regard of Exhibit 1 and 2, it has already been discussed in issue number 4 and accordingly decided in favor of the plaintiff. So, Exhibit 5 is the alleged sale deed number so-and-so executed by the defendant number 4 in favor of defendant number 1 so-and-so, which is challenged by the plaintiff. On bare perusal of the alleged deed, it is seen that the defendant number 4, Bimalendu Das, sold out the suit land to the defendant number 1, Sri Omoresh Das, claiming his right of inheritance from his father, late Rakesh Das. So it is admitted by the plaintiff that Bimalendu Das is one of the Pattadar by after demise of his father Rakesh Chandra Das, his name is included. And it is admitted in the evidence of the PW1. But his right of inheritance is challenged by the plaintiff, submitting that he is the tenant of the said suit land, which had been settled by the predecessor of the defendant number 4. So this finding Your Lordship. To prove his tenancy under such a pattadar, he has submitted Exhibit 1 and Exhibit 2, which is found correct and authenticate. But the defendant could not submit any documentary evidence except some Xerox paper in respect of his right of inheritance. So this is not required to be proved by the defendant number 4, his right of inheritance. It is an admitted fact that he is one of the pattadar. The learned trial court held that he has to prove that the defendant could not submit any documentary evidence except some Xerox paper so and so right of inheritance. Right of inheritance of my vendor. And it is admitted by the plaintiff that my vendor is one of the pattadar. The defendant side could not show any evidence of the fact that his father, from whom he claims his right of inheritance, was the exclusive owner of the Sweetland. Sweetland, the pattadar, there are 6 pattadar. So no need to prove that his father was the only pattadar of the Sweetland. It is a joint property, as Mali. So the plaintiff also did not abide or did not state in bring to it evidence that the Robindra Chandra Das, from whom he claimed that he is a tenant, he was the exclusive owner of the whole property. From the pleadings document submitted by the either party and the oral evidence, it appears that the plaintiff was recognized as tenant and his name was entered in the final khotiyan on the basis of such tenancy right, and since then he has been in possession of the Sweetland prior to the registration of the alleged deed number so and so. So possession is determined only on the basis of khotiyan, Your Lordship. Not a single witness is discussed whether the witness has stated who was in possession. Not a single witness is discussed. Only on the basis of the khotiyan, it is held that he is in possession. Since the Sweetland had already been settled upon the plaintiff and his right was not terminated by any provision of law, his right cannot be interfered by way of selling the Sweetland by anybody else. As such, it can be held that the defendant number 4 also out of the Sweetland by deed number so and so without having any right title over it. So where the plaintiff admitted that my vendor is a pattadar, which is as per section 58 of the Evidence
Your
Act.
case is basically based on cross evidence of PW1.
All the
CG admitted that your vendor was one of the pattadar.
one of the pattadar. And another aspect is that, and that is as per section 58, the facts admitted need not be proved.
But except the document, that is the certified copy of the sale deed, you could not produce any other document.
Any other document, no need to prove.
No, whatever, you have not produced.
Yes, not you. Yeah. Then, my lord, regarding the cancellation of my sale deed, assuming that the tenant has the ownership right, that is wrongly held, because the section 23 of the Assam Temporary Settled Tenancy Act may refer her. This section provides the procedure. How?
Section 23.
23 of the Assam Temporary Settled Tenancy Act 1971. Because both the trial court and appeal court only held that both the courts below held the petitioner, plaintiff as a tenant. The finding is that he is a tenant. But holding him as a tenant, my sale deed is cancelled. It is not held that he has the right title and interest about the land. And this provision provides how a tenant can acquire ownership. A tenant has to acquire the ownership, lordship, as per this act. And as per this act, if he had proved before the trial court that he has acquired the ownership as per provision of law, And it is not the case of the plaintiff also that he has paid for declaring the right title and interest. The plaintiff himself did not pray for a declaration of right title and interest, Your Lordship. He has prayed for only a tenancy right, and his tenancy right is declared. Declaring his tenancy right, the valid sale deed executed by the landlord is set aside. Section 23 provides, Your Lordship,
Yes.
acquisition of ownership rights and intermediate rights by the tenants. Tenants have to acquire any occupancy tenant personally cultivating the land of his tenancy. This is also important. One thing, the plaintiff admitted in his evidence that he was a teacher by profession. It is also in the evidence of his evidence. But here it is said, any occupancy tenant personally cultivating the land of his tenancy, desirous of acquiring the ownership right of his landlord. The tenant has to acquire the ownership right of his landlord. But that is not the case of the plaintiff here. Desirous of acquiring the ownership right of his landlord may at any time make an application. He has to make an application in writing to the Deputy Commissioner, and on such application being made and compensation as provided in Section 25 is determined and paid by the occupancy tenant, the Deputy Commissioner shall declare the said occupancy tenant to have acquired the ownership right free from all encumbrances. So the ownership right is to be conferred by the Deputy Commissioner as per provision of this Act. And if the plaintiff could have proved that he had acquired the ownership right, then my sale deed could have been set aside. Because in that case, the tenant would have been the owner and only he has the right to transfer. So the compensation is page number 24. What is the compensation? The total compensation payable for acquiring the ownership right as well as the intermediate rights, if any of any holding, shall be an amount of equal to 50 times the full rate of annual land revenue payable for such land. Now, Section 26. In all cases of acquisition under this chapter, the Deputy Commissioner shall give notice to the landlord and all other persons having interest in the land, and also fix a copy thereof in a conspicuous place of his office. He shall thereafter make an inquiry as prescribed here, objection, if any, and then make an order.
Lordship, sorry, I am interrupting, but I think these are not relevant to this case, Lordship. This is in regard to acquisition by government from the landlord, land acquisition from the landlord. As per Section 25, apportionment of compensation where an occupancy tenant is personally cultivating the holding, his landlord shall be entitled to receive the entire amount of 50 times of land revenue. That is in regard to the calculation by the government where acquiring a land.
But I complete, then my friend will reply.
Lordship already, he's
My
taking
friend will reply.
so much time, Lordship.
This is not an act for acquisition of land acquisition act. It is not a land acquisition act. Assam Temporary Settled Area Tenancy Act is an act, Your Lordship, to provide some rights to the tenants. Before that, there was a system of Adiyar system, Your Lordship is aware of, that the farmers will cultivate the land on the basis of Adiyar, and in years after years, by getting only some amounts or quantity of the produce they get from the landlord, and to protect the right of the farmers, this act is enacted, Your Lordship. It is not land acquisition act, as my friends have stated. It is for the protection of the rights of the tenants, and even this act provides that the tenant can acquire the ownership right of the land, and it is the ownership right, Section 23, how a ownership right a occupancy tenant can get. That is the clear provision. How it is acquisition is there is no nothing is there in this. The aims and object is only to protect the right of the tenants, Your Lordship. This act is enacted. So this section 26 is there is a procedure. I am reading that there is a procedure for acquiring the ownership right of the land. And my submission is that my purpose of submitting this point is that it is not a case of the plaintiff that he is the owner of the land and he has acquired the ownership. So only he can transfer the land by a registered sale and the landlord cannot transfer. It is not the case of the plaintiff. Not in the trial court, not the appeal court. Appellate court. He is satisfied with his tenancy and his prayer. I have in the very first I have Your Lordship drawn the attention of the prayer that he has only prayed for the tenancy right and the learned courts below held he has a tenancy right. So regarding the first substantial question of law, my submission is that since he has not acquired the ownership right, he has only tenancy right and the landlord has the ownership right and he can transfer the land, and it is admitted position that he has admission of the plaintiff is that the my vendor is the landlord, one of the landlords, or one of the pattadar, so he has the right to transfer he has validly transferred the land, Your Lordship. And regarding this finding of the trial court that the plaintiff defendant could not prove their case, I have submitted one judgment of this honorable court 2007 2 GLR Jodu Thakur and another. Paragraph number 10. Page number 10. Page number 10. 1, 2, 3, 4. Paragraph 10, second subpara I merit, only subpara I read. A civil suit is to be decided. A civil suit is to be decided as per the provisions and discipline of the law as provided under the Code of Civil Procedure, which do not permit imparting of such a document without amendment of the pleading and bringing to in record by permissible legal procedure. In fact, allowing such procedure, the learned appellate court has even complete to go by the procedural aspect relating to pleading and proof in a civil suit. This further says that in the impugned judgment, though the appellate court has held that the said application pertains to a share of the principal respondent, allowed the appeal dismissing the claim of other two plaintiffs without making any discussion thereon, and in the absence of the alleged admission by them, the said application was so and so, which is not exhibited document, in fact, cannot have any adverse effect on the claim of the plaintiff, and the appellate court wholly accepts.
Show by this judgment.
My last two line, last 4 line. It is right law that title to the property cannot pass on mere admission only, and it is the responsibility of the person who come to the court for declaration of his right, title and interest to prove the same. Here it is found that the plaintiff is on the plaintiff's case, it is presumed by or assumed by the learned courts below that he is the owner, but he is not proved his title. That was the plaintiff's duty to prove his title. Here the plaintiff did not prove his title over the land. So regarding the first application of law, my submission is that it is a finding of the courts below that he is a tenant, he is not the owner of the land. So based on his tenancy right, the first application of law is rightly formulated by this honorable court, and this application of law is involved in this case, and the honorable court may held that since both the court declared him a tenant, and based on his tenancy right, my sale deed, validly registered sale deed by the landlord cannot be set aside and declared as null and void. And regarding the second perversity, I have shown the trial court judgment that none of the witnesses has been discussed. Now I will draw your lordship to the appellate judgment for a moment. The trial court did not discuss any of the witnesses, the statements of any of the witnesses. Now page number 9 is the appellate court judgment. The appellate court also did not discuss any of the witnesses' submissions. Page number 15, your lords. Page number 15, the Honorable First Appellate Court formulated 2 points to be decided. In the last part, your lordship, points whether the plaintiff took tenancy settlement of the suite land from his original owner in the year so and so. So here also the learned appellate court did not go to the rightful interest of the plaintiff, only the tenancy right, whether he had acquired tenancy right is there. And number 2, whether the sale deed number so and so executed by defendant number 4 in favor of defendant 1 in respect of suite land in the year so and so is valid. So only 2 points have been formulated. So how this point decided, I may be allowed a few minutes to read, your lordship. Point number 1, without discussing the evidence of the witnesses, plaintiff, in order to substantiate his claim that he took tenancy settlement of the suite measuring 1 biga for so and so covered by the so and so final Khotian so and so. I have perused the aforesaid final Khotian, and on perusal of the aforesaid Khotian, it appears that the suite land covered by so and so is settled with the plaintiff along with other land covered by different ducts measuring several bigas of land by his original owner, including Rakesh Chandra Das and Rabindra Chandra Das, as claimed by the plaintiff. So it is the case of the plaintiff also that it is the admitted fact that my vendor's father was also a landlord of the plaintiff. Now, if we draw our attention to section 58.5 of the Assam Temporary Settled Areas Tenancy Act, section 58.5, we will find that it categorically stated that every entry in record of right finally published shall be conclusive evidence of the matter referred to so and such entry and shall be presumed to be correct. So we have no objection in this provision of law that he has been correctly entered. So it is held that he has been correctly entered as a tenant, then also my right is not affected as a purchaser. Further, the Honorable Court, High Court also in the case of so and so state that every entry in the records of right regarding final published shall be conclusive evidence of the matter referred to in so and so, presumed to be correct unless is proved in evidence incorrect. The burden of the proof that such entry is correct on the persons so asserted. So these findings are regarding the validity of the Khotian, regarding the tenancy right. So now the being position of law, I am of the considered opinion that the burden of proving that the final Khotian is incorrect rests upon the defendant when the statutory presumption is in favor of the plaintiff. As per Exhibit 1 document, we know that presumption makes a prima facie case for a party whose favor it exists. Now let us see whether defendant has discharged his liability to find the answer. Let us peruse WS. The perusal of WS submitted by defendant so and so reveals that the defendant number 124 in para 8 of their WS also admitted the fact that the name of the plaintiff is recorded in final Khotian number so and so against the suit land. No higher, they took plea that it was recorded wrongly in the Khotian and same was issued collusively by defendant number 5 to 7. This finding, your lordship, is though it is mentioned, but it is wrongly held, because page number 14 for a moment is, I have earlier also page number 14 regarding that non-challenging of the entry. I refer to page number 14 for a moment. Page number 14. Next, I will go to the WS lordship. But if we peruse the entire materials available on records, we will find that there is no iota of evidence, be it oral or documentary, to substantiate their claim that the name of the plaintiff is wrongly recorded in the respect of suite land in Exhibit 1 document, nor plaintiff. That is right, lordship. There is no evidence from the defendant side that it is wrongly entered. Now, in the instant case, Exhibit 1 document makes out a case, and there is a statutory presumption of so and so Assam Temporary Tenancy Act in favor of plaintiff. So defendant is duty bound to prove the pollution and set forth the ground on the strength of which claimed the final Khotian was wrongly recorded, but the instant case, the materials available on record. So the finding of the appellate court, without discussing any of the evidence regarding perversity, Lordship, the appellate court is confined its finding only to the validity of the Khotian. Validity of Khotian, it is without challenge, it is final. So, but regarding the title or ownership of the and possession of the plaintiff, none of the evidence of the witnesses has been discussed. It is only on the provision of law regarding the validity of the Khotian, the case appellate court decided the point number 1 in his favor. Now, point number 2, as regarding my validity of my registered deed, my lord, as regards point, let us first draw our attention to section 7 of the Transfer of Property Act, which deals with the person competent to transfer. The aforesaid section reveals that in order to dispose of transferable property, the transfer must be competent to contract and have title to the property or authority to transfer it, not his own. Now, the instant case, as we have found in the discussion made in point number 1, that a tenancy settlement in respect of Sweetland is already been made in the year 1368 by the predecessor of the defendant number 4 in favor of plaintiff. So I am of the considered opinion that defendant number 4 had no title over the property as mandated by section 7 of the Transfer of Property Act. So the appellate court held that since he is a tenant under the predecessor of my vendor, so I cannot transfer the land. This is the finding of the appellate court. No title about the property. Since he is a tenant, I have no title to transfer the land. As mandated by section transfer property to transfer the sweet land again in favor of the defendant 1. The defendant number 4, being a person not competent to transfer, cannot transfer the sweet land in favor of the defendant number 1. So I am of the considered opinion that the document so and so is executed by the defendant 4 in favor of the so and so is void document. Further, if we draw our attention to the recital of prime document of the defendant number 1, that is the sale deed, exhibit A, we will find that it does not tally with the averment made in paragraph 8 of the WS. Exhibit A reveals that defendant number 4 claims right title and interest and possession over the sweet land after the death of his father, and he, in order to meet his urgent need of money, sold the sweet land and handed over possession of the sweet land to defendant number 1 on the date of execution of the sale deed. So in every sale deed, there is a statement that on the date of execution, I handed over the possession. In every sale deed, and accordingly in this sale deed also there is a statement that he has handed over, defendant number 4 has handed over the possession on the execution of the sale deed. And in the WS, there is a plea of the defendant that they are in possession.
To make it shorter.
It is only a few 5 minutes or 10 minutes. The plea in the WS that they are in possession from before the purchase of the sale deed. That is mentioned, dear Lordship. That they had the rent payment receipt. So they were also tenant before the purchase of the land, and that could not be proved by adducing the original rent receipts. This is stated that, but it is a fact that on the date of purchase they have in possession. They are in possession. If it is, they have proved it is, though they could not prove before that. On 2706, the date of registration of the sale deed. But the case of the defendant in para 8 is somewhat different. Para 8 reveals that defendant 1 is occupancy tenant of late Rakesh Chandra Das, father of so and so. Now, if we believe the versions of the defendant WS supported by an affidavit, then exhibit A to be considered as false, because both the person cannot be in possession of the sweet land at the same time. So the appellate court held it is a false document. A registered sale is a false document because we could not prove our possession prior to the execution of the sale deed, for which it is a false document. The contradictory averments of the defendant so and so exhibit document itself nullify the claim of defendant and indicates towards the fact that exhibit A documents executed by defendant number 4 in respect of sweet land in favor is illegal and document, void document. So in the light of the above discussion, so this is the finding of the appellate court. So in the sum and substance, my submission is that the first certification of law is involved in this case, since the tenancy right is declared by both the courts below, and by declaring the tenancy right, my sale deed has been declared as void. Though it is admitted that my vendor is a patadar of the land, and the plaintiff could not prove that he has acquired the ownership right as per provision of law. So the landlord has no right to transfer the property. His case only to declare the tenancy right, but the landed courts below presumed or assumed that he has the ownership right and declared my registered sale deed as void and null and void. And the second question of perversity, I have read both the judgments. The Lordship will find that in both the judgment, none of the witnesses have been discussed, and without discussing the
Trial court judgment.
yes, trial court
Judgment at page.
trial court judgment is page, Your Lordship, page 30. Trial court judgment 3030, and issue number 4.
No, I'm not.
Trial court judgment, Your Lordship, page number 34 is the issues, and decision is page number 36, Your Lord. Page number 36, 37, and 38. Neither the trial court discussed the evidences of the witnesses. The one of the witness is also an employee of the sub-register office. Sub-register office, the witness number 2, DW2, Gurupada Das, has proved that my sale deed. And
We are saying that right title interest of the plaintiff is also been declared. It's not declared. Decree is not
declared. Only tenancy.
Tenancy right is only declared.
Only declared.
I was saying that the right title interest of the plaintiff was
Plaintiff,
also
not declared.
Presumed. It is the
Presume,
you
that
have
means
to say that it is the presumption of the court
that means
that he possesses the right title interest.
yeah,
Not there,
but my submission is that, my lord, because it is not mentioned, but declaring my sale deed as void on the finding that the plaintiff is a tenant. Plaintiff is a tenant of the landlord, my sale deed is cancelled. So it can be presumed that he is a owner, he is a title holder of the land, so landlord cannot transfer the land. This is my
anyway.
So this is my submission. Lordship, only one judgment I last cite regarding the plaintiff case cannot be decreed on the witness of the defendant. Supreme Court judgment, one judgment of 1998, 9 SCC 1, one judgment, 1999 SCC 719, Supreme Court judgment, paragraph 4. It, however, appears to us that although the High Court indicated in the impugned judgment that the defendant's claim of easement right and also the claim of the title by way of adverse possession could not be accepted, such weakness in the defendant's title to the suit property cannot establish the plaintiff's title. So in that case, the Supreme Court held that on the weakness of the defendant's case, the plaintiff's case cannot be decreed. I am not going to read the one of the one judgment I have submitted to Lordship. Guwahati High Court judgment regarding this issue here, regarding the weakness of the defendant.
May please, Your Lordship. In this case, Lordship, plaintiff's case is that, Lordship, there were 5 recorded patadars, Lordship. Page 56, paragraph 2, Lordship. Kindly see. So his predecessor is one of the patadar that is already admitted. Page 56.
Yes.
Paragraph 2, that the suit land and some other lands in Mauda, Banerpur, Kitse, Monsancho, Police Station, Karimganj, pertaining to periodic patta number so and so belong to Rakesh Chandra Das, predecessor of defendant number 4. Rabindra Chandra Das, sons of late Ramlochan Das of village Mahakal under police station Badurpur in landholder right. They were the Patadars in respect of the land of the said periodic Patta number so and so. Said Patadars are the predecessors of the principal defendant number 4, Sri Bimalendu Das, and the proforma defendants. In 1368 Bangla Son, the plaintiff took tenancy, settlement of the suit land and some more lands, total measuring about 46 caters. As per record of rights prepared by the government after survey, the total area is 40 bighas, 2 kathas, 14 chataks. From the said Pattadars, Rakesh Chandra Das and Rabindra Chandra Das at an annual rate of ₹40, the government on the basis of title and possession of the plaintiff as tenant over the suit land and some more lands prepared final Khatiyan number 468 of so and so. Under the relevant provisions made in the Assam Temporarily Settled Areas Act 1971 of 1971, the rules so and so, said record of rights was finally published in 1975. So, Lordship, my Khatiyan was published in the year 1975 and the suit was filed in the year 2006. 1975 without any objection from any quarter and it stands unrebutted. There was no objection, Lordship. As per law said, final Khatiyan number 468 has become of the title deeds of the plaintiff so far as the suit and some other lands mentioned therein are concerned. That in the above manner, the plaintiff has been possessing the suit land and some other lands, some more lands as mentioned in the said final Khatiyan number so and so for last 45 years as occupancy tenant within the meaning of subsection 1(1) of section 4 of the Assam Tenancy Act. The suit land is Jalatak land, means it's some kind of fishery land. Lordship. In rainy season, it becomes fishery, and in dry season, they cultivate. Every year, the plaintiff catches fish from the suit land, and when water recedes, that is in winter season, every year he cultivates barrow paddy in the suit land and appropriates the same for consumption of the members of his family, including himself. That Sri Bimalendu Das, the principal defendant number 4, by hoodwinking the government side principal so and so and in collusion with the principal defendant number 1, Sri Amaresh Das, and his sons, the principal defendant number 2 and 3, created a so-called registered Kapola number so and so for the suit land. By this registered Kapola, July 2006, no title and possession over the suit land passed on Sri Amaresh Das. So the case of the plaintiff is that by that time, Bimalendu Das do not have any title over the suit land. So the registered deed which was executed in favor of defendant number 1, that is invalid. So there was a prayer for cancellation of the registered sale. And defendant number 1 is claiming his right over the suit land on the basis of tenancy as well as on the basis of this registered deed. So two contradictory claims are there by the defendant number 1. So, Lordship, when the cancellation of the registered deed was prayed by the plaintiff, there was no counterclaim by the defendant number 1. As Lordship, as soon as we prayed for cancellation of the registered deed on the basis of which the defendant number 1 is claiming his right title interest, there is a cloud over his title, Lordship. Even then, Lordship, the defendant number 1 did not file any counterclaim. Now paragraph 5, Lordship. That the principal defendant number 1, 2, and 3 have no title and possession over the suit land. The suit land and the other lands mentioned in the said final Khatiyan cannot be the lands retained by the said Pattadars as per provisions made in the Assam Fixation of Ceiling Landholdings Act 1956. Because as mentioned above, the Patta holders settle the suit land and other lands as mentioned in the said final Khatiyan number so and so with the plaintiff on tenancy basis. The defendant number 4, the Bimalendu Das, has no first possession over any portion of land mentioned in the said final Khatiyan number so and so. The principal defendant number 4, said Bimalendu Das, has no rights whatsoever to execute the registered Kapola dated so and so. The principal defendant number 4 most illegally with ulterior motive has given the following wrong description in the schedule of the said Kapala number so and so. So these are the boundary, lordship. Thereafter, it is the case of the plaintiff that Kabbalah is invalidly executed. So there is a prayer for cancellation of the Kabbalah, lordship. Accordingly, both the courts held that your lordship will find title suit judgment. My learned friend has submitted that the oral evidence of the defendant's witnesses were not considered. Issue number 4, lordship, page 36. When deciding the plaintiff's tenancy right in issue number 4, when the learned trial court came to a decision that plaintiff able to prove his right, then lordship, the defendant's witnesses were considered. I'm not reading the entire issue number 4, lordship. Page 37, your lordship will. Plaintiff proved exhibit 1 and 2 in original, lordship. So the court came to a decision that plaintiff able to prove his right title. On the other hand, paragraph 2, lordship, on the other hand, to deny the case of the plaintiff, the defendants in their evidence submitted that the suit land is exclusively belongs to the father of the defendant number 4 by way of periodic Kiras Patta number 1. So their plea is that it is exclusively belong to Rakesh. Our case is that it is belong to Rakesh, Ravindra, and some other person. Five other persons. By way of periodic Kiras Patta number 1 and Banirgul Modas, after the death of his father, he became the owner of the suit land. The defendant Sri Amaresh Chandra Das also denied that late Ravindra Chandra was the patadar of the said suit, but the name of the plaintiff was wrongly recorded in Exhibit 1. On bare perusal of Exhibit 1, it is seen that name of Ravindra Das was entered into the said final Khatian as patadar along with 5 others. So we have proved the Exhibit 1 in original, and from the Exhibit 1, court came to a decision that there are Rakesh, Ravindra, and 5 others. It is there in the Khatian version. Hence, the contention raised by the defendant DW1. My learned friend is submitting that the evidence of DWs were not considered, lordship. The court came to a decision on the basis of DWs, lordship. Ravindra Chandra Das was not the patadar. Hence, the contention raised by the defendant DW1 to the fact that Ravindra Chandra Das was not the patadar of Khatian number so and so cannot be accepted. In regards of wrong entry of the name of the plaintiff in Exhibit 1, that is Khatian number 468, no causal evidence has been cited by the defendant side. However, the defendant side filed Xerox copy of periodic Kiras Patta number 1 issued in favor of his father, late Rakesh Chandra Das, and some of the rent receipt issued by said Rakesh Chandra Das, but has not been examined with the original. But in the plaintiff's lordship exhibited Exhibit 2, that is a Parag lordship in favor of plaintiff by Rakesh Chandra Das, his father, lordship, defendant number 4's father. And they have exhibited all the photostat copies, lordship, Xerox copy. Being the mere Xerox copy, these documents carry no evidentiary value at all. If we carefully and comparatively scrutinize those documents, then it appears that the documents submitted by the plaintiff side are the original documents, and the documents submitted by the defendant side are mere Xerox copies. As such, the documents of the plaintiff have high evidentiary value with respect to the documents submitted by the defendant. I also perused the schedule and boundary submitted by the defendant in case of denial the schedule and boundary of the plaintiff, and found that both the schedule and the boundary are same without having any contradiction. So, lordship, there are clear discussion by the trial court about the evidences and pleading of the plaintiff, and after coming to lordship a finding that plaintiff able to prove his case, then the evidences of defendants were discussed by the learned trial. In view of above discussion and reasoning, it appears that the plaintiff was the tenant under the patadar late Ravindra Chandra Das and others, and his name was rightly included in final Khatian number 468. Accordingly, this issue is decided in favor of the plaintiff and against the defendant. So there is a discussion of DW lordship. My learned friend's submission that his DWs were not considered. That is not the case, lordship. In fact, all the evidences were discussed by both the courts, lordship. And everything. Issue number 5, while issue number 5 was decided, page 38, lordship. In the middle portion here, lordship will find, but the defendant could not submit it. My learned friend has already read out the entire issue, so I am just pointing out the
Yes, but the
portions
defendant-
where the learned trial court discussed. But the defendant could not submitted any documentary evidence except Xerox paper in respect of his right of inheritance. The defendant side could not show any evidence to the fact that his father, from whom he claims his right of inheritance, was the exclusive owner of the suit. So this is his case, lordship. The Bimalendu Das was the owner of the suit land on the basis of the ownership of his father. So his case is that his father was the exclusive owner. That not be proved by the lordship defendant number 4. From the pleadings, documents submitted by the either party and the oral evidences. So oral evidences were taken into consideration. It appears that the plaintiff was recognized as tenant and his name was entered into the final Khatian on the basis of such tenancy right, and since then he has been in possession of the suit land prior to the registration of the LS deed number so and so. So, lordship, after taking consideration of the oral evidences of both the parties, both the courts came to the concurrent finding, lordship. So it is not possible for a second appellate court to go to the oral evidence of all the witnesses, lordship. Since the suit land had already been settled upon the plaintiff and his right was not terminated by any provision of law, his right cannot be interfered by way of selling the suit land by anybody else. As such, it can be held that the defendant number 4 sold out the suit land by deed number so and so without having any right title over it. Accordingly, this issue is also decided in favor of the plaintiff and against the defendant. Thereafter, the decree, lordship, issue number 6, the other consequential reliefs granted to the plaintiffs are mentioned in the form of following order. Plaintiff, the plaintiff is a tenant of having the tenancy right over the suit land as described in the schedule. Possession of the plaintiff over the suit land as described in the schedule of the plaintiff is confirmed until and unless he has been evicted by due process of law. Defendants are restrained not to interfere with the peaceful enjoyment of the suit land as mentioned in the schedule by the plaintiff. The alleged deed so and so is declared to be collusive, illegal, and is void ab initio. If defendant number 1 is so much of serious about his title lordship on the basis of deed lordship, there ought to have been a counterclaim. So the substantial question of law which was formulated lordship on last occasion by another court lordship, not by this court, that was last formulated the second substantial question of lordship. It is not sustainable as because already all the evidences of the DWs were considered by both the courts. And their case is they are submitting that plaintiff has to prove his own case. If plaintiff has to prove his own case and plaintiff able to prove his case, then why it is necessary to discuss the DW's lordship? Already plaintiff able to his case lordship. On the weakness of the defendants, plaintiff's case was not decided. Plaintiff's case was decided on the basis of the original document submitted by the plaintiff. And thereafter, lordship, the defendant's case was discussed, and then both the courts find that there was no evidence which can be, lordship, included to prove the case of the defendant. So there was no evidence by the defendants to be taken into consideration to lordship prove the pleadings as it is by the defendant in their written statement. And the appellate court in page 16 point number 1 rightly held that the Khatian which was lordship prepared on the basis of Assam Land Revenue Regulation Act, lordship, Assam Settled Areas Tenancy Act, in the year 1975 and long back, Lordship. Thereafter, no objection was raised. Suddenly, in the year 2008, a suit was filed, Lordship. Even there was a no prayer for cancellation of the Khatiyan. And it is admitted by DW1 in his cross that the Khatiyan was prepared in the name of the plaintiff. We came to know, even thereafter, we have not prayed for cancellation of the Khatiyan, Lordship. The DW1, I'm reading, Lordship, it is in Bangla. নালেশা জমি বাদী মুনীন্দ্র দাসের নামে এক্সিবিট 1 দ্বারা রেকর্ডভুক্ত হয় এবং ইহা আমি মোকদ্দমা হওয়ার পর জানিতে পারি। যখন আমার এক্সিবিট এ দলিল করি তখন নালিশা দাগ 1097 কাহার নামে হয় তাহা আমি খোঁজ করি নাই। আমি মোকদ্দমার পর যখন আমি এক্সিবিট 1 দ্বারা নালিশা জমি মনীন্দ্রর নামে ফাইনাল খতিয়ান হওয়ার পরও আমি কোনো আপত্তি দেই নাই। So they remain silent, Lordship. And he himself admitting that রাকেশ চন্দ্র ভাইয়েরা 5 ভাই ছিলেন। রাকেশ চন্দ্র দাসের আরো এক ভাই রবীন্দ্রচন্দ্র দাস ও মিরাজদার ছিলেন। So he is also a পাট্টাদার. It is admitted by DW1, Lordship. 1 নম্বর পাট্টা রাকেশ বাবুর নামে মৃত রাকেশ চন্দ্র দাসের 2 ছেলের এবং কন্যা রেখে মারা যান। রাকেশ চন্দ্র দাসের এক ছেলে ছিলেন উকিল বিমলেন্দু কুমার দাস ও সে ডাক্তার ছিল রণেন্দ্র কুমার দাস। রণেন্দ্র দাসের Lordship, therefore it's not necessary. So it is admitted by the DW that Rakesh and Ravindra are brothers. They were 5 brothers and they both were Mirazdar, means they both were the pattadar of that patta. So my exhibit 2 was also issued by Rakesh Chandra Das. So that was proved in original. So there remains nothing to discuss, Lordship, as already all the witnesses were discussed. And they have stated that the Khatiyan was fraudulently created. The allegation of fraud, Lordship, that is as per order 6 rule 4, it should be specific, Lordship. There is a mere statement that the Khatiyan was created fraudulently in para 8, Lordship.
Para 8 of WS.
Of the WS. That was discussed by the first appellate court that in para 8 they have taken a stand that that was fraudulently created, but they could not substantiate that pleading by way of by giving evidence to prove that fact. Order 6 rule 4, Lordship, of CPC particulars to be given where necessary.
Yes, you can.
In all cases in which the party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all other cases in which particulars may be necessary, beyond such as are exemplified in the forms aforesaid, particulars with dates and items, if necessary, shall be stated in the pleading. Lordship, mere statement that the Khatiyan was fraudulently prepared, Lordship. Paragraph 8, that the answering defendant do not admit the requirements of paras 1, 2, and 3 of the plain as true and the correct, expecting what is specifically admitted in the written statement. The suit land absolutely belonged to Rakesh Chandra Das, since that father of the answering defendant number 4, he was the pattadar of the entire suit land. So they are pleased that the suit land absolutely belonged to Rakesh Chandra Das, that they cannot be proved by the defendants. Along with same other land recorded in periodic Hiras Patta number 1 of Moza Swenso, Ravindra Chandra Das had no right title or possession into the suit land, but Ravindra Chandra name is there and DW1 also admitted. The plaintiff was never settled with the suit land by the said landowner, owner Rakesh Chandra Das, but the exhibit 2 was issued by Rakesh Chandra Das. Exhibit 2 is there. The name of the plaintiff was wrongly recorded in the final Khatiyan.
What is exhibit 2 in?
Exhibit 2, Lordship, Parag, that is issued by Rakesh Chandra Das in favor of the plaintiff. Lordship. Parag or Dakila is a revenue receipt. It's kind of revenue
Oh, just
receipt.
Parag, yes.
Yes. That was issued by Rakesh Chandra Das. The signature is there, Lordship. I'll come to that, Lordship. The allegation of fraud, Lordship, only these two lines. The name of the plaintiff was wrongly recorded, page 63. In the final Khatian number 468, it is collusively issued in his favor by the defendant numbers 5 to 7. Only this line. So as per order 6 rule 4, it is not specific. There are constitution bench judgment on the fraud, Lordship. I'll submit later on, Lordship. The said final Khatian does not confer any right title to the plaintiff. The suit land is a law-lying borrow petty land. The plaintiff neither produced borrow petty over the suit land nor did he use the same for fishery purpose. While said Rakesh Chandra Das was possessing the suit land along with some other land situated adjacent to the suit land, he expired in the year 1970. These are not necessary, Lordship. These are the TW4 is the legal heir of Rakesh Chandra Das and it is admitted, Lordship. So their case is that, Lordship, the plaintiff has to prove his own case. That is, both the courts decided that by the original documents, plaintiff able to prove his case. And on the weakness of defendants, plaintiff suit cannot be declared. There was no discussion about this, that on the weakness of defendant, plaintiff suit was decided, Lordship. And moreover, the defendant could not prove their case as they failed to adduce original documents. Both the courts decided to. On the basis of that, defendant's plea was negated by trial court as well as by the first appeal court. And Lordship, the question of fact, those are whether the DW oral evidences were considered or not, Lordship. For that, the second appeal section 100 is not possible to reverse a concurrent finding of both the courts below in regard to question of facts, Lordship. If there is substantial question of law, Lordship, there is perversity, then Lordship, the second appellate court has wide power to interfere with. So my humble submission, Lordship, both the courts rightly decided the suit of the respondents, Lordship, and decreed the suit. And there is no such substantial question of law, which was my learned friend argued.
Please, the Lordship. Regarding the exhibit,
Lordship, I have completed.
your Lordship,
No, just
Government is there. Lordship.
yes, comment.
Government.
I will,
Oh, he is replying only, no?
Yeah,
That's
yes.
why I'm asking you only to submit if you have any. How?
आपने कोई दे-
Yes, yes.
Lord, actually, I was listening, my lord, that the whole thing is that our government stand is that the land now is actually now government land, my lord. And originally, before 1977, 77, it was under the under private possession. So in 19 in late sealing case number 330 of 1977-78 under the Assam Sealing Act of 1956, the land became government khas land. In case number 330 of 1978. So, my lord, we have filed a affidavit on 13/6/17. So my lord can take that up and the affidavit filed by the respondents 2, 3, 4, and 5, that is the government respondents, on 13/6/2017. My lord got it, the affidavit
Which page?
at page 2 of the affidavit, paragraph 4.
I mean, which page is that?
The affidavit was filed in this case, my lord. Affidavit dated 13/6/17. Or my lord can note it down later on. My lord can look into the record.
No, you just tell us in
Yes.
which page it is available.
My lord will
Page.
note down the affidavit. Affidavit
No,
filed by
which
the
page it is annexed here.
at
Which
page 2. Page 2.
No, not your page 2, in appeal memo.
My lord.
Beleg Assembly.
No. It is an independent affidavit. No. We had filed in the second appeal, my lord. It was filed after the memo was filed.
You have received the copy.
Yes, I
It's not available. Why? I don't know.
supply. They have not contested the suit. They did not file any WS. The government did not file any WS in the suit.
In the suit, we did not file anything. And we,
No, suit is not here. You have filed affidavit.
in the second appeal,
Affidavit is not available in the record. That's what I'm asking.
yes. Now my lord got it.
For record.
You have filed it in before in I it is available only. Interlocutory application number.
Oh, yes, my lord. Yes, that is the copy, my lord. Yes, that is one. In the top, it is written IA civil number 1534 of 16 in RSA number 219 of 16.
Yes, what do you want to submit? Come to.
At page 2,
Hmm.
my lord, that with regard to the statements in paragraph 3 and 6 of the RSA, the deponent begs to state as per the land record, Sri Manindra Chandra Das, son of late Ramendra Das, was a tenant of the suit land covered by DAG number 1097, measuring an area of 1 bigha 14 katha 04 chatak, along with other lands under the patadars of Robindra Chandra Das and 5 others, son of late Ramachandra Das in tenancy final Khatian number 468 of Mouza, Banyar Gali Kite, and Manasabha Pargana Igarsati, and subsequently the above data has been made government khas land under the late sealing case number 330 of 1977-78. Now, here, actually there is some confusion regarding the ownership and tenancy. So here I would add that both are true and both are untrue at different times, my lord. So before 1978 and 78, the question of ownership of the private parties was there. And so the land, if somebody wanted to transfer the land, they have to go through a sale deed before 77, 78. That means ownership could have been transferred before that. But after 77, 78, when it became government khas land, the only thing that can be transferred is the tenancy, not the ownership. So that is very important, my lord. After 77, 78, only the tenancy rights can be transferred. And after 77, 78 till now, the government remains the government khas land. And the people who are in possession before that has remained in possession. And after 77, 78, whatever rights were transferred was the tenancy rights. And regarding the matter, that is with our records at page 36, issue number 4, in the judgment of the original court at page 36 of the title appeal. So there it has been published that the government records were finally published in 1975. That is before the sealing case. That is before the sealing case. So until then, the ownership would have been transferred. And after 77, 78, only tenancy can be transferred. And regarding the finding of the lower, both the lower courts is there. There at page 37 of the title second appeal. In the middle part of the page, my lord, I'm reading out. In regards to the wrong entry of the name of the plaintiff in Exhibit 1, i.e. Khatian number 468 number of cogent evidence has been cited by the defendant side. However, defendant side filed Xerox copy of the periodic Hiraz Pata number 1 issued in favor of his father, late Rakesh Chandra Das, and some of the recent receipts issued by Rakesh Chandra Das, but has not been examined with the original. Being mere Xerox copy, these documents carry no evidentiary value at all. If we carefully and comparatively scrutinize these documents, then it appears that the documents signed on plaintiff side are original documents, and documents signed on defense side are mere Xerox copies. My lord, that is why the Xerox copies are not matching with our records, man. The original papers are matching, and that has been recorded. So that is, I think, my lord, the confusion is clear now. Before 1970-78, the ownership can be transferred. After 77-78, only the tenancy rights can be transferred, but it will remain government after 77. That is, and the law, my lord, will find it that the Sealing Act of Assam in 1956. How this tenancy law is actually applied, because a man cannot hold more than certain amount of land. So it has to be given to somebody else. And if there is nobody among the relatives, it becomes government land. So I think any doubt regarding the records, and I don't, because there is some, and the Xerox copies has not matched with the record. That is, and regarding the new substantial question of law formulated by this court, that is at on 14/8/2025, the account on account of non-considerable evidence of defendant witnesses 1, 2, 3, and 4 in deciding the issue at the point of deterrence at the time of hearing. Now, this non-consideration, actually, why it has happened, I'm explaining, because the Xerox copies of these defendants had given as evidence did not match with the record. So that is why their evidence was only explained. Just now I read it out that Xerox copy cannot be does not have any evidentiary value until it is matched with the original. That is the Indian Evidence Act 90 from 60 section 61 to 65, the old Indian Evidence Act that will be applicable here, not the new one. And so so that is why the consideration of evidence, actual the physical evidence was not considered because they are Xerox copy. So I think that explains the new issue that was formulated in the court. And the other facts that was discussed.
Yes.
And so I think the confusion is now gone. Why this confusion has happened? Because of the ceiling case, man. And both things are true at different times, and both things are untrue at the other time. What is true before 77, 78 may not be true after 70. So, my lord, I'm KK Bhattacharya, appearing for the state of Assam, respondents number 2, 3, 4, and 5. And the other act that is coming, besides the Ceiling Law Act, the Assam Tenancy Temporary Settled Areas Tenancy Act 1971. That, my lord, may go through. That may be relevant. So that is all, my lord. Like,
Well, regarding my London Corporate Council,
You want to again reply?
my lord,
But we have a meeting in fact.
only only I will just reply the exhibit 2. My friend relied. Exhibit 2 is it is under objection, my lord. That is relied with the land my learned friend has. I will page number 74. Only one paragraph I will read. Page number 74 regarding the exhibit 2. What the PW1 stated. Page number 74 of the memo of appeal. The PW1 admitted that it is an overwritten document and for which it is an objected document. First, second, third, fourth, fifth paragraph from the top, 74. Second, third, fourth, fifth. In exhibit 2, against the column, Jut Jamin Poriman. Jut Jamin Poriman within comma 3 is overwritten with different ink and word chukti against column Barsik Khazna is written by different ink. So this is exhibit 2 is a manipulated record exhibit. It is admitted by the plaintiff number 1. I paid land rent for the year so and so. It is not a fact that exhibit 2 is a false, and it is not issued by the Rakesh Chandra Pal. Exhibit 2 is the document of Rakesh Chandra Pal. In exhibit 2, there is no Chita Dag number and boundary so and so. It is not a fact that the TOSI is given in exhibit 2 is false. Exhibit 2 is under objection. So my friend relied upon exhibit 2, and it is admitted by the plaintiff that it is overwritten. It is written in different ink, so it is under objection. And regarding one of the point my friend relied that regarding the filing of any counterclaim. So there is no question of filing any counterclaim because the defendant's case is a valid. He is a valid purchaser, and the plaintiff has claimed the land, the suit land, the purchased land of the plaintiff, which is under the defendant's possession, and the since the defendant did not claim that he is the rightly interest over the suit land, so there is no question of filing any counterclaim. For this is my humble submission.
Lordship, only I am pointing out this is exhibit 2, Lordship. From C file, your Lordship will find this is exhibit 2, Jamidar name Rakesh Chandra, Das and others.
So he is saying that there is some overlapping and ink.
Lordship, maybe they have objected, but it is in original. Your Lordship may go to the file, Lordship. The plaintiff proved it in original. And Lordship, the plaintiffs have taken a stand that under ceiling surplus land, the land was acquisition. And Lordship, kindly go through section 16 of the ceiling surplus. thereafter it was settled in favor of the plaintiff. So now they become landholder. In fact, these plaintiffs ought to have claimed right title interest on the basis of landholders' right title interest, but they have claimed tenancy right. Section 16 of the Assam Fixation of Ceiling on Landholdings Act 1956.
Mr. Bhattacharjee has referred one ceiling case number 330.
Lordship, this is Assam Fixation of Ceiling on Landholding Acts 1956.
No, yes. He has already referred one ceiling case number 330 of 1978.
Lordship, the lands were taken by the government acquisition from the jamindars, and thereafter the lands were settled with the plaintiff, Lordship. So the plaint itself contained the word settled, Lordship. Paragraph 2 I read out, Lordship, that paragraph 2, in between, the government on the basis of title and possession of the plaintiff as tenant over the suit land and some more lands prepared Khatiyan number so and so under police station concern under relevant provisions made in Assam tenancy areas so and so, and there is a word settled, Lordship. So the lands were settled with the plaintiff's, Lordship, so they became landholder. After 16, your Lordship will find 16.2. On payment of the full amount under subsection 1 above, the land shall be settled with him with the status of a landholder, as defined in the Assam Land and Revenue Regulation 1886. If it is taken from the jamindar, then the tenant who were occupying the land.
Now you are saying that the matter is certainly your
Lordship, it is there in the
title is also in your
Lordship.
favor,
That
but
can also be their claim, but they have claimed the only
have not-
tenancy,
it's not
Lordship.
there.
So I have not argued that point, Lordship. But as per Ceiling Tenancy Act, the lands were settled with them, Lordship. And the lands were settled with them, it is already mentioned in plain, Lordship. I have seen that word settled is there, Lordship. In paragraph 2 itself, Lordship.
In
Para 2, Lordship, I have seen.
But there is no evidence, my lord, of settlement.
For that only the Khatiyan was issued in favor of the plaintiffs, Lordship. That is why the plaintiff in para 2 said that final Khatiyan has become the title deeds of the plaintiff. But in prayer, Lordship, they have asked for tenancy right, Lordship. That was
My
the
lord,
mistake.
settlement always means issuing a patta, my lord. Settlement means issuing a patta, and Khatiyan is not a patta, my lord.
Equivalent to patta,
Khatiyan is not
Lordship.
a patta. It is a record of rights, my lord.
Patta and Khatiyan are all same, Lordship. Earlier it was recorded as Khatiyan. Paragraph 5, Lordship. Paragraph 5, fifth line, Lordship. The Assam Fixation of Ceiling on Landholdings Act 1956, as mentioned above, the patta holders settled the suit land and other lands as mentioned in the final Khatiyan. So it became government land. It became patta number 1, Khatiyan number 1, and thereafter it was issued in favor of the plaintiff, Lordship.